Okay. I guess can you hear me?
Yeah, sure. What's up? Yeah, what's up? Can you hear me?
Yeah, I can hear you. All right, guys. Sorry, I'm just apologies. The professor is running late, so we're just going to wait for him a little bit. I don't know if you, Nyasha, are you there? Okay. Right. Apologies to all the listeners that are tuned in. Thank you. Normally our programs run on time. Regrettably, we've not been able to get the professor to come in to join in early. He sends his word that he'll be with us shortly. So we're going to be slightly delayed, and the debate will commence. I suppose in the meantime, we'll simply just wait. I'll be popping in and out just to make sure that I'm chasing him up. Michelle, how is our sound doing, and how are we looking visually? Or may as well just get the test all done.
Sound good and visuals are looking good.
Okay, great. And Doc, are you going to have your visuals on, or are you going to be? You're good to go with your visuals. Okay, cool. How's the Doc's posture and his side visuals?
All good on this side.
Okay, great. Nyasha, are you going to turn your camera on, please? Is Nyasha? Did you speak to Nyasha? Is she online yet?
Nyasha is around. She has just gone quickly to take a break. She'll be back in a second.
Okay, great. No problem.
Did some
All right, great.
yeah.
So since everything is okay for now, our listeners, so we have 139 people watching, 140 rather. It's going up rapidly. Please do bear with us. We're just waiting for our. Nyasha, are you going to take your camera? The professor.
It's off now. Can you see me? Can you hear me?
Yeah, I can hear you. We can't see. Yeah, I can see you. So visuals are good. Michelle?
I'm here.
I'm saying Nyasha's visuals, are they good? Since everything is okay for now.
Visuals are looking good, but she is behind a bit.
Okay, can you hear me now?
Connect again.
Do you want me to come out and come back in?
Yes, please.
No, it's your positioning.
She was just lagging just a little bit.
Okay, so while you guys are setting up, maybe Nyasha, if you just speak to the audience as I just quickly chase up the prof and make sure that he is on his way. So while you guys are setting up,
Hi, Nyasha.
Yep, can you hear me?
Right. We can hear you now.
Brilliant.
Have you got something running in the background?
I will switch off Twitter.
Thank you. Yeah, so Farai has just popped out to go and check on the professor, who we are just currently waiting on. Please bear with us as we wait on the professor. Nyasha, if there's anything you'd like to say to the audience about what we will be doing here today, please feel free to go ahead.
Yeah, okay, there we go. Well, a lot of it I'll leave Farai to fully introduce the panel discussion today. But as it states, it's an academic discourse, a panel discussion on the Constitution of Zimbabwe, the amendment number 3, Bill 2026, apologies. So I'll let Farai, when he comes back in, go through the introductions, and then hopefully we'll have Professor Jonathan Moyo back, and we can go through the discussions with both Dr. Hofisi and Professor Moyo. Thanks, Michelle.
Thank you, Nyasha.
Right. The Prof should be joining us now, and we should be good to go. Right. Sorry, Michelle, can you just check my sound again? Yeah, the Prof is now with us. He's on stage. Add to stage. Welcome, Prof. Okay, we're good to go. Michelle, are you with me?
I'm here. Go ahead.
Apologies. Professor, can you hear me? The mute button should be
Professor, if you could unmute your mic, please.
Right. Okay. So can you just check, Michelle, can you just double check the professor's mic?
And the professor has left. I think he's just trying to rejoin again. Bear with.
Okay, cool. Just keep an eye out for that. All right, guys. Apologies yet again for the lateness. Like I said, we try to make it a good tradition to respect your time. There was a bit of confusion given the time differences. We are actually broadcasting live from the UK, so the GMT differences with the East African time. Apologies to everyone who has come early. We do respect your time, and we sincerely apologize for the inconvenience, which is, of course, not deliberate. But of course, we're about to have an important discussion as a country. And I want to thank everyone that has joined us. From me and my team, the Southern African Times, with us. You may not see her, but just in the background, there's Michelle Mungeni, who's doing our sound check in engineering. And my co-host is here live. Nyasha, could you kindly turn your camera on? Thank you so much. And we're about to begin. Now, we're just going to do a quick sound check with the professor, because everyone has done a sound check. Professor, thank you for joining us. Could you quickly check your mic, please?
Excuse me?
Yeah, we're just doing a mic check, Prof. We just want to check your mic.
Yeah. Can you
Michelle,
hear me?
are you happy?
Yep, the professor's coming through.
Okay, great. All right, Professor, we're going to begin now. So we will start. I will quickly start with an introduction. Thank you yet again all for joining me, and I want to profusely apologize for the time. Like I said, we respect your time, and it's terribly inconvenient, but this is really on us. A bit of confusion around the timelines. I had miscalculated East African time. So Professor was in another meeting, and he had planned his day already. But fortunately, we have him here, and we have the good Dr. Hofisi with us, and my co-host, Nyasha, who will equally introduce herself soon. Now, good evening and welcome to the Southern African Times Academic Panel Discourse on the Constitution of Zimbabwe Amendment Bill number 3, 2026. Tonight's discussion engages one of the most consequential constitutional questions in Zimbabwe today. At its core are issues of democratic legitimacy, constitutional interpretation, and the balance between institutional continuity and public accountability. This forum is convened by the Southern African Times in partnership with the Ministry of Information and Broadcasting Services of Zimbabwe, and Press Reader, who are our proud partners today in terms of content sharing. We're committed to fostering an informed and structured discussion, and we anticipate that you will find it to be objective this evening and quite straightforward. We want to facilitate rigorous evidence-based exchange. This is not a partisan debate, but it's an academic interrogation of law, principles, and consequence. Before we begin, a brief humanizing note. Now, both of our speakers share an unexpected common background beyond politics and law. Professor Jonathan Moyo has contributed to Zimbabwe's musical landscape, including writing for groups like Pax Afro and composing songs such as Sisonke, which became one of the cultural backdrops during the land reform period. Dr. Hofisi as well, on the other hand, has released music publicly, including the album Zinambwe, and earlier work reflecting a creative discipline alongside his legal scholarship. So while tonight is about constitutional law, it is also about a sense of meeting of two minds who understand structure, rhythm, and composition in more ways than one. Now, as we go into the segment, I'd like to quickly give a brief background to our speakers, our panelists. So Professor Moyo is a political scientist and former Minister of Higher and Tertiary Education. He has argued that the proposed amendment to section number 95 relates to the length of term rather than a term limit provision, and therefore does not trigger the constitutional requirement for a referendum. Dr. Tinashe Hofisi, on the other hand, is a constitutional law scholar and postdoctoral research associate at the Kash Institute of Democracy at the University of Virginia. He has written extensively on constitutional reform in Zimbabwe and argues that the cumulative effect of Bill number 3 represents a fundamental restructuring of democratic governance and accountability. Now, we are going to explore these particular arguments by beginning, of course, with the professors, with the pro argument, which will be introduced by Professor Jonathan Moyo. So to simply give you a brief layout of the conversation, we're going to have the presentation for the motion. So Professor Jonathan Moyo is going to make his case, after which, for 20 minutes, of course, after which Dr. Hofisi will then make his case, the argument for against. There'll be a rebuttal sessions of 5 minutes each for 3 rounds, after which the moderators will then ask questions. From then, we will be able to we'll then get closing arguments, well, rather not closing arguments, but arguments in response to what the moderators have asked. And then we'll go to a Q&A. We anticipate that this entire conversation should take about 2 hours. So please bear with us. Now, if you have your questions, please do place them in the comment section, and our friends in our team will pick them up, share your name and your position, and we'll be able to ensure that it is answered. With that, with no further ado, I'd like to introduce Professor Jonathan Moyo, who is making the argument for the proposition. Thank you so much for joining us.
Thank you, Farai. And may I begin by thanking the Southern African Times, the Ministry of Information, and Press Reader, who are the organizers of this, I'm told, academic discourse on the Constitution of Zimbabwe Amendment number 3 Bill 2026. And I would like to apologize for the confusion over time. I was told this was going to be at 9 p.m. East African time, and I thought I had a lot of time on my side, and I was in a commitment, a prior commitment. I apologize on my behalf, but also on behalf of the organizers for the miscommunication. I'm a bit surprised. I expected this to be a space, or spaces as they call it, which is audio and sound based. But I see, although without a full comprehension of what it is, that I'm in a studio, and there may be some people who are seeing me whom I cannot see. I don't take any responsibility for that if they find anything wrong with what they are seeing. Now, I have 20 minutes and I've squandered 2 or 3 of those minutes. I hope the organizers will be kind enough to give me.
I think you can pardon that. Not a problem.
Yes. Now, it is common cause that what we are focused on today in the form of the bill was gazetted some 66 days ago on 16 February 2026, which means there are some 66 days gone and therefore only 24 to go before the bill clocks its 90-day period of public consultation. under the auspices of Parliament. Its tabling for the first reading is therefore now a matter of weeks away. The reality of the bill becoming law is now in front of us. I would like to contextualize my opening remarks by sharing with you two fundamental background assumptions or context of the bill, which I believe are very important to understand in order to appreciate its key provisions and the other provisions which support it. Firstly, it is important to keep in mind that this discourse we are having today is intended to assist lawmaking in Parliament and lawmakers in particular. In this connection, it should go without saying that the art of lawmaking is, of course, very different from the art or even the science of interpreting the law, which is the business of professional lawyers. There's a reason why an overwhelming majority of lawmakers are not lawyers. They are ordinary people who represent ordinary communities and society at large. When they frame or make law, lawmakers express the values and the prevailing as well as enduring interests of the publics that they represent. As such, lawmaking in general and constitution making or constitution amendment in particular are fundamentally about the social compact and the national interest. This is why under section 152, subsection 3A of the Constitution, the Parliamentary Legal Committee must examine every bill other than a constitutional bill before it receives its final vote in the Senate or the National Assembly. The fact that a constitutional bill, such as the bill before us, is not subject to review by the Parliamentary Legal Committee speaks volumes about the full and unhindered sovereignty that members of Parliament have and must have when it comes to constitution making or constitution amendment, as is the case with this bill. The noise that often comes from certain quarters to imply that constitution amendment is for lawyers is therefore uninformed and misguided. If the Parliamentary Legal Committee, a constitutional body of lawyers who are members of Parliament, has no say, why should any other lawyer claim a special say or privilege on account of their profession? Secondly, and related to the need to contextualize this discourse by being alive to the question of who the lawmakers are and why there's also a critical need to be alive to the question of the fundamental mischief that has given rise to the bill before us, that is. Why are we debating this bill or discussing it today? Some would say we're doing this in order, or that the bill rather, is intended to entrench the power of the president. That therefore we are examining it for that reason, to examine it in terms of the implications thereof. Others say the bill is to address or even to resolve the succession question in ZANU-PF as the governing party. While these are not political issues that one can just dismiss out of hand, politics being what it is everywhere and every time. I must say, with all respect, that those who think or assert that the bill is about entrenching the personal power of the president or about managing the succession question in ZANU-PF are wrong. It is my considered view, and personally, I have reflected on this question quite considerably and systematically, not only with respect to Zimbabwe, but in the context of state politics in Africa today. And it is my view that the real question that remains unanswered in our body politic, which is the mischief being addressed by the bill, has two intertwined aspects. On the one hand, there's the aspect of the perpetual conflict mode rooted in the country's electoral system in general, but particularly related to the election of the head of state and government. Now, how a country elects its chief executive determines its national politics. In most of Africa, Zimbabwe included, this question has hitherto not been given the attention it deserves. The post-colonial parliamentary systems inherited by the independence period were quickly and without much thought replaced by very strong presidential systems that either led to or anticipated one-party, one-man rule based on direct elections, where the presidential election practically became the only election that mattered. The scourge of disputed elections, allegations of rigging, political violence, ethnic tensions, and divisions all typically center around this heritage of direct election of the president. Related to the method or system of electing the president has been the dilemma, or even, shall we say, the problem of shorter 5-year terms of office or election cycles that invariably foster perpetual election modes by the opposition and its sponsors, which invariably triggers survival modes by ruling parties or governments. When the opposition defaults into perpetual electioneering modes in between elections, ruling political parties tend to invariably respond by defaulting into perpetual survival modes. The shorter 5-year term or terms incubate and breed societal divisions. Recent data from the 16 African countries in the Commonwealth, which elect their presidents directly, shows without any doubt that shorter terms of office adopted in post-colonial constitutions in the name of promoting democracy and accountability tend to incentivize divisive rhetoric, ethnic mobilization, and the neglect of long-term infrastructural programs in fragile contexts, which have weak institutions, and this then tends to perpetuate instability. From a structural point of view, the perennial election mode we see in most of African countries, and certainly ours, engenders conflict mongering through false populism with endless and often unproven claims that the government of the day is illegitimate from election to election. And this happens without let or hindrance, and making it difficult for government to discharge its governance responsibility. So, from the point of view of the opposition under the law of perpetual electioneering, cooperating with the government on any issue becomes a cardinal sin. On the other hand, and also from a structural point of view, the survival mode of the ruling authorities tends to engender a climate of fear by seeing and treating the opposition as inherently unpatriotic, harmful to the national interest, and subversive by definition. In the circumstances, policy making, especially long-term policy making focused on infrastructural development and/or projects, is derailed. Service delivery collapses, corruption becomes rampant, patronage festers, state institutions get demonized and weakened, while public trust erodes. Some say this situation is easy or could be easy to resolve. After all, they claim people, especially those in power, should simply change their behavior because they are the ones in power. They should just let citizens have their way. Others who support those in power or who are in power often say malcontents in the opposition should change their behavior and become patriotic, nationalist, and loyal. The proposition that those who default or whose default engagement in politics is a perpetual election mode, and those in power whose default response is a perpetual survival mode should simply change their behavior are mistaken, those with that view, even when they mean well. Only God can change human behavior. Students of human organization know only too well that the best and arguably the only way of dealing with negative human behavior, such as perpetual election modes and perpetual survival modes, is by structuring the decision premises of the players or actors in question, even communities. The works of the pioneering thinkers like Adam Smith, The Wealth of Nations, Max Weber, Economy and Society, and even the likes of Herbert Simon, Administrative Behavior, address precisely this kind of enduring structural questions. Against this backdrop, and in my considered view, the Constitution of Zimbabwe Amendment Number 3 bill is a structural response to the undeniable situation that now permeates our country and most of our continent. The situation of perpetual electioneering mode of malcontents in the opposition and the perpetual survival mode of the system is what needs to be dealt with. That's why I do not subscribe to the easy and convenient notion that the bill seeks to entrench the personal power of the president, or that it seeks to redefine or restructure our system of government to deal with the succession question in ZANU-PF. That, from an analytical point of view, cannot possibly be true. In my analysis, the bill primarily seeks to address two state politics questions that I intimated at the beginning of my intervention, which I'm about to close. One, the bill comes up with a more palatable, more sustainable, more inclusive method of electing the president, which is consistent with universal adult suffrage and is rooted in tried and tested principles of representative democracy. Two, the bill addresses the question of shorter election terms, which is being widely debated across the continent regarding the electoral cycles for the three elective branches of government: the office of president, not the president, but the office of president; parliament, not the MPs, but parliament as an institution; and local councils, not local councillors, but local councils as institution. As I read the bill, it does not give me any impression, or I don't see any content that deals with the personalities. The bill addresses this issue of shorter electoral cycles or terms by lengthening the time from 5 to 7 years, and not by extending it, the term of office, that is, or the length of office. It doesn't extend it from 2028 to 2030, as some claim, but it lengthens it from 4 September 2023 to 5 September 2030. And that is how the 7 years is calculated as I read the bill. So finally, and in conclusion, because these are issues I believe will come up in the discussion, I would like to point out what the bill, when we focus on the contentious clause, which is section 95 subsection 2b, does. What does it do? It safeguards and preserves the presidential term limit in section 91(2). It precludes a third term or the repeal of the presidential term limit. It doesn't do either. It refrains from extending the presidential term in section 91 subsection 2. It circumvents section 328 subsection 7, which pertains only to term limit provisions. It lengthens the election cycle from 5 to 7 years. It impacts all elective positions, notably parliament, not just the presidents, but also local councils, as I pointed out. And this is what the bill does with reference to the most important section.
One more minute, Prof.
In order to help you with that 1 more minute, I'm going to give it to you and reserve the more specific questions about the clauses of the bill for discussion, for open discussion. I thank you.
Thank you so much, Professor Jonathan Moyo, who is our former Minister of Higher Education, Higher and Tertiary Education. Now, the next speaker is against the motion. And this is Dr. Hofisi, just in case you've just joined us. This is Dr. Hofisi, a constitutional lawyer who is a post-doctoral student or candidate, if you will. We're currently with the University of Virginia. Dr. Hofisi, welcome to the platform, and please do take the stage and make your case. Thank you.
Thank you very much. I hope I am audible, and thank you very much to Professor Jonathan Moyo. I certainly concur with the sentiments that we heard from Farai. As a musician myself, I am grateful for the brief renaissance you gave to Zimbabwe music in your time. Now, having said that, I'm going to begin my discussion by talking about referendums in the Zimbabwean constitution and precisely why we have them. So I'm going to talk first about constitutional theory to situate what exactly I'm talking about. So there's a word that people use, certainly lawyers, when they're talking about constitutions, and the word is entrenchment. Probably some of you have heard entrenched clauses. What is to entrench? Generally, constitutions are more difficult to change than ordinary statutes. In order to have national stability, you need to have this one norm, this ground norm that doesn't change easily. But sometimes within the constitution, certain parts are even more difficult to amend than others. And those are the entrenched clauses. And there's many ways to entrench clauses. One is to render the section immutable. Another is to require unanimity within the legislative body to change that. And another, which is the one that Zimbabwe chose, is to have a provision for a referendum. And what is exactly is the logic of a referendum? It is because people, the undifferentiated people, when the professor was saying this is not just a discussion for lawyers, certainly. So everybody has got this power to make a constitution, no matter what it is, right? Monarchy, non-monarchy. Parliament has got the power to change that. So when we are talking in constitutional law, we distinguish that as the constituent power. That's the power to make a constitution. And that power resides in the people. And then there's the constituted power, the power to act in terms of the constitution. And that is the power of parliament. Now, the Zimbabwe constitution separates which provisions the constituted power of parliament can just change, and the ones for which they need the constituent power. They need everybody. You have to go back for the changes to be legitimate. And that is because this is exactly, to me as a listener, what VNA means, the real VNA. This is the constitution telling you that when you want to make certain changes, you have to implicate the real VNA of the people. And it's not, for those who are familiar with certain customs, I'm certainly familiar with the ones in Kore tradition. When the wife has her first pregnancy, she must go back to the mother, right, to be taken care of. Why is that the case? She's in a new family. We thought she was a new daughter-in-law. Yeah. There's this constituted arrangement where she's married, but she remains ours. And if she dies, we have to come and bury our person. It's the same relationship that the Constitution is establishing. These certain provisions, you have to go back, right, to the people. They are the ones who own this. They are the real VNA. And which ones are those? Now, I understand them to be three provisions: rights, extension of incumbency for term-limited provisions, and the amendment procedures themselves, right? So rights, Chapter 4 rights, Chapter 16 rights. I know there's more to it, but broadly speaking, rights to agricultural land and the other human rights. And then the other ones, extending the tenure of a term-limited office, and the third, changing these rules. Those are the three that you have to come back to the people. But why must you come back to the people? Why can't Parliament just act? It is because when you write a constitution, what is a constitution about? Heinz Kluge, the University of Wisconsin-Madison, likes to say constitutions are about power. We think about good things, right? And it's all about power, right? We are constituting the state. This is where public power comes from. And we are all theoretically at least giving up some private power in order to enjoy that public power, the protection, the state, the police. So you're constituting power. But in that constitution, if you read the entire constitution, these powers are given to specific bodies, to Parliament, to this commission. It's all certain arms of the state or government. The power that we retain as a people, we call those human rights. This is the power that we retain when we can actually access that public power in order to protect ourselves. And because the human rights, the rights to agricultural land, these declaration of rights, those rights are within the people. You want to change that, you go back to the people, right? And why are people in power? I'm going to talk about this a bit. Where do they derive their authority? It is from the people. So if the people vote for you for 5 years, after 5 years you go. You want to stay longer? Go back to the people, right? You have to change that rule that you have to go, and for that you have to go back to the people. That is the theory, right? These are the real VNA, and you have to go back to the people. And that is the reason why we've got these strong protections against these specific rights. Now I want to take the discussion, now that I've spoken about why we need to go back to the people. I want to talk about the provisions for which we are being told you do not need to go to the people. And I'm going to express why I do not agree with that view. So there are two different views. If you listen to the professor speaking, he was talking about, look, this actually does not implicate section 328 subsection 7. It's not a term limit. It's just a cycle. So there's this view that 328 is not relevant at all because of these reasons and others, which I'm sure we'll hear. And then there's the other view. Where do we get that other view? In the bill itself. So the bill, I am arguing, does not agree with this proposition that it's not a term limit provision, because the bill is in fact saying you can amend term limit provisions using a notwithstanding clause. And as far as I can tell, these two views, one cannot maintain both, at least, and maintain logical coherence. Either it doesn't implicate section 328 subsection 7, or it does and you need a notwithstanding clause. But there is both. If you read the bill, it references them. So I want to talk about those, and then perhaps in the Q&A, I can indulge and say why I think we've got these different views that are being advanced for the bill. So The Zimbabwean constitution, fortunately, unlike many around the world, defines what a term limit provision is, right? So it locks us in, and the term limit is in reference to length of time that a person may hold or occupy a public office. So it limits the length of time. That is what the provision, and I invite everyone to literally read what 328 section says. When we say these provisions, lawyer or non-lawyer, let's all go and read the provision. What does it say? Do you limit based on length of time, right? And if you read the Maximum Pungu judgment, which everyone has been talking about, that's what the Constitutional Court did. Okay, so which are the provisions that have a unit of time? Where is the unit of time? That is the term limit provision in Zimbabwe, as defined by the Constitution. And so it seems pretty clear when we're talking about the president, where exactly is the unit of time, right? And if anybody doesn't agree, then you need to convince the court otherwise that where exactly is the length of time, because it to me appears very, very simple. We are all working in a bar. Everybody can only work for 2 shifts, right? There's a 2-shift limit, but then the shift is defined as 5 hours, right? That is, and then there's a prohibition against extending the amount of time that a worker will work, workers' rights and that sort of thing. But then we've got the time that everyone must leave the bar. After your shift, you can stay in the bar, but at 10 p.m., everyone has to leave the bar. And the court tells us that's an age limit. Everybody leaves at this hour, no matter what time you entered, no matter time you spent there. But there is a distinct limitation of the amount of time you can work a shift, right? So when there's that challenge as to whether the Chief Justice must go, the Constitutional Court tells us, well, the Chief Justice does not have to go, because there's a distinction between age limit and term limit because of the way that I'm framing it. And the arguments now are that actually, actually, even though the court told us in pretty uncertain terms that Section 95 is a term limit, there was an error because it perhaps is an election cycle, as we're being told. And I think we'll discuss that more and more. But my understanding from the judgment and a limitation of time is that you have to go back to VNA if you want to lengthen that time, as I said about the referendum, because the time that the incumbent gets is coming from the people. And this is the other part I want to talk about. The Zimbabwean constitution is also unique in that each arm of the state is deriving authority from the people. Many constitutions have got authority that derives from the constitution itself. And then other constitutions such as Zimbabwe, but also Zambia, Malawi, you also find this provision in Uganda, in Kenya, where the authority to govern still resides in the people, right? And then those in authority have to act in terms of the constitution. But in Zimbabwe, you will find each arm of the state is deriving from the people. That is to say, why do you need to go back if you want to extend the term? Because your authority is deriving from the people for elective office. For the judiciary, it is constituted in a different way, and I can talk about that if we still have time. But for elective office, you derive your authority from the people. You want to get more time, you go back to the people. You go back to VNA, as I said in the beginning. Now, I find a very interesting this argument that Section 95(2)(b) is actually an election cycle. Yet again, I challenge everybody to read the provision. What does the provision say? That the term of office of the president extends until A, they resign or are removed, and B, following an election, there's declaration of a new president. And as otherwise provided in the Constitution, and otherwise provided, as far as I'm concerned, there means otherwise the person resigns, right? You resign sooner, you are removed sooner, or we are waiting for declaration of a new president. The term of office is 5 years. The term of office is 5 years, and coterminous with parliament. Now, I'm going to be interested to find out from the professor how he defines an election cycle, because I look at that provision, I cannot find the cycle. I can find a reference to waiting for declaration of a president, and he said when he was speaking that this also affects local councils. I can't find them. So why is that the election cycle? My understanding, at least, and he's free to dispute this, is that an election cycle is the legally prescribed interval between at which elections for a particular office must be held, right? The applicable time period between elections. And I'm looking at it. I can't find it. And I'm more than happy to be shown how that is the election cycle. But in so doing, I make my claim that let's look at Section 158 of the Constitution, which is entitled Timing of Elections. And what does that provide? A general election must be held right? A, 30 days before expiry of the 5-year period in 143, but where Parliament has passed a resolution to dissolve, but where the Parliament is dissolved, and subsection 2, general elections to local authorities. That's where I find this reference he's making to local authorities. It's in 158. General elections to local councils must take place concurrently with presidential and parliamentary general elections. And polling in by-elections, it seems to me 158 is the election cycle. And I know when it comes to interpreting constitutions, as the professor said, this is not necessarily about lawyers, but I know if I were in a court, if I were in the constitutional court, then certainly there is an interpretive rule against superfluity, right? That the people who give us laws, they don't just add on text that doesn't actually have a distinct reason that is different from the other provision. This to me seems like the election cycle, and I am fortified by the fact that this is the election cycle because of the other point I made about what happens if you look at the actual bill. If you look at the bill and look at the references it makes to the changes, that is to say, if you look at section 4 and 9b, the ones which reference section 95 and 143 in order to keep the president and parliament in power, it references section 328 and says, yeah, notwithstanding, and the notwithstanding is what I will talk about in the time I have left. Notwithstanding, we are superseding that, right? And it does for those provisions, but when it does refer to what I'm calling the election cycle, 158, there is no reference to 328 there because they know it. This one is not a term limit provision. 95 is, 143 for parliament is, because any limitation of your length of time, right? Parliament is limited to 5 years, renewable. The president is limited to 5 years, which is renewable once we read these two provisions together. So it seems to me that we have the election cycle provision already in 158, and I don't know how that relates to 95. And if you read the Max Mpungu judgment, you will see this reference to this rule against superfluity, right? There's a reason why these provisions are in the Constitution. Now, in the time I have left, I think I should talk about the notwithstanding provisions. Now, many lawyers are familiar with this word notwithstanding, right? To withstand is to prevent, to resist, right? So notwithstanding means not prevented by. I'm going to do it anyway, right? So in laws, in statutes, in constitutions, notwithstanding what they call non-obstante clauses, others would prefer to call them. So they create this internal hierarchy where this provision is going to be operational in spite of that other one, in spite of what that provision says. That's how notwithstanding works, right? Like, oh yeah, he was dating that girl in spite of the subsistence of a marriage. He was notwithstanding the subsistence. He was not prevented by that. So in the bill, we are being told that, hey, section 328 has got something about this, right? And that's what I'm saying. It's a term limit provision. Otherwise, there will be no reference to 328. But we're proceeding anyway. We are proceeding anyway. Where do we get that authority? I am not entirely certain. I am happy to inform everybody that across the world, the power to use a notwithstanding provision against a fundamental clause is very rare, but it's there. Canada has it in section 23 for their Charter on Fundamental Freedoms, but it's for very specific rights, and you cannot affect rights like the right to vote, and it has to be confirmed in the next election. Same thing if you look in the Israeli basic laws, and in fact, in all countries where you have this notwithstanding power, you will note one, it is a place where there's parliamentary sovereignty, right? This reference by the professor to the sovereignty of parliament. These are not instances like ours where it's a constitutional democracy. These are parliamentary democracies, and the legislature then has this power to issue notwithstanding clauses. But in Canada, that has never actually been used, the notwithstanding provision. It's that controversial. It's been used by some provinces like Quebec, but it's that controversial, and I'm not sure where we locate this power to use ordinary constitutional text in order to override an entrenched provision, right? Ordinary text to override what is entrenched. Remember what I said about the Vene, which is why if you read the Musa Kika judgment and the Max Mpungu judgment, Max Mpungu overturns Kika, both of them, right? The High Court and the Constitutional Court, they all agree, okay, first of all, this notwithstanding provision is evidence that the government is trying to change a term limit provision. And both courts in different ways kind of say, yeah, but we can't enforce this. We can't enforce this. The High Court, the Constitutional Court says they need to avoid infringement of Section 328, whilst the High Court says they need to read the law in order to prevent conflict with express provisions of Section 328, subsection 7. And I am more than willing to talk at a theoretical sense about why this was the finding of the court. But what we are learning there is the courts are kind of signaling there's a procedural hierarchy, right? This notwithstanding, this override, even if you enact it, we are still going to give effect to Section 328 as long as you concede it has not been amended. And that's what they're trying to do with the notwithstanding clause, right? We are amending, but we're not amending, you know. But the court, yes, 328 been amended. If not, the High Court said Malaba has to go, and then the Constitutional Court says Malaba stays only because it's an age limit provision, which is why we're having this discussion about what exactly amounts to a age limit or term limit. But the reason, right, you cannot, notwithstanding the people, is that this is where the authority to govern comes from. So those who work for, perhaps in the public service, there are some people after retirement where the government can allow you to work on one-year contracts, which is kind of the same as what the Constitution did for judges with the Second Amendment, that if you come to the president and he accepts, right, your medical certificate that you can serve, then you can serve for 5 years beyond your retirement age. Now, why are you going to the president as a judge? Because the president is the appointing authority. Is the appointing authority happy with you extending beyond retirement age? Do they accept your medical certificate? Then you can continue. Now we can imagine if the judge simply says, hey, as the judiciary, we can just extend. We don't care about the appointing authority. And this is the exact thing about the referenda, that you have to go back to the people in order to get your authority to govern, because the Constitution kind of says you must respect the people, and that's where the authority is derived in the founding values, but also very distinctly for these branches of government. Now, I am going to deal perhaps in more detail with this question of elections when we are dealing with questions coming from the people. This question of the removal of presidential elections as being the unique factor, the but-for factor. But for presidential elections in Zimbabwe would not be violent. But for presidential elections, there wouldn't be disputed elections, right? There wouldn't be instability. The problem, as we are being told, is a democratic institution. It's not the actors. It's not the operating conditions. It's not impunity. It's the election itself. And I think that's a very interesting approach if we are to kind of reach this stage where we agree that if there's bullying in schools, let's get rid of schools, for instance, right? Or if there's a problem with domestic violence, let's get rid of marriages. That the problem is the institution, not the actors, or at least we're not going to seek to address the actors, but somehow we are just accepting at a level. And I'm trying here to express why I oppose this idea that African people in general, and Zimbabweans in particular, just cannot vote for a president without devolving into violence. They just have some inherent violence in them, for which the presidential election must be removed. I find that objectionable. I'm not sure I need to say more based on that, other than let me conclude, because I'm almost out of time. In this 1 minute, I want to say,
Hofisi, you have an additional 5 minutes, given that Prof we had given him more time. So please feel free. You have an additional 5 minutes.
Okay, thank you. Oh, I wasn't aware of that. Good for me. So I wanted to say, first of all, so here is my, I want to say, let me begin by pointing this out. The professor has told about these post-independence constitutions. Now, the Ethiopian scholar who is now the justice minister in Ethiopia, Gideon Hesebon, you can look up this fascinating article on the fourth wave of constitution making. And the fourth wave is what led to the constitution of Zimbabwe, of Kenya, of South Sudan, and various other constitutional reform processes. So scholars speak in waves of constitution making, right? The first wave in Africa is the independence constitutions, right? And, generally having these indirect elections, Lancaster. And then you've got a second wave, which is the one he's talking about, where you have establishment of executive presidencies, but also establishment of one-party states, dictatorships, coups. We're talking about the 60s into the 70s. The third wave is the early 90s, the fall of the USSR, and then you've got reestablishment of multi-party democracies. This is where you get Zambia 91, Malawi 94, South Africa 94, Uganda 95. And so you've got this rights-based wave of constitution making, and then you've got the fourth wave, which was then dealing with term limits, right? The fourth wave is then dealing with this question: how can we control the executive? How can we devolve powers, right? And these are the questions from the fourth wave. And I find from what we're hearing from the professor, there's this conflation as though the second wave, which was the one which was establishing strong men dictatorships, Banda becomes president for life, right? It was a thing to have a constitution, to have a president for life. And to locate the problem with the second wave is term limits, other than the fact that there were not effective elections in that time. In multi-party democracy had to be reestablished by the third wave. Now, there are distinct problems I have other than with the narrative of what we're talking about when we are removing the election of the president. You as a rights holder, you elected the president for 5 years. And this is why this language of cycle is very important. I elected you for 5 years. There's a legitimate expectation that you're going to come back after 5 years, and I evaluate. That's the basis of democracy. Do I endorse? Do I not? So, but then if you take away the institution, what have you done to the right? Right? I was voting for 4 levels. Now it's 3. And you're telling me the right remains unencumbered, unhindered? This is like I filed a case for my client in court, and then on the return date, I'm told the Constitutional Court has been abolished. It's gone. We did not have disputed elections until we gave people a forum in which to dispute them. That's the problem. And then you're going to say, but Hofisi, the Constitutional Court, Chapter 4. Not in Chapter 4. The Constitutional Court is not in Chapter 4. It's established distinctly. Chapter 4 does not give you the court where you go. It refers to a court, and will tell you you can go to the royal court. We're establishing a monarchy. Yeah, it's fine. You still have your right. Do you? Do you? If that is the thinking, that tomorrow we can be told that there is no election of the president because it's too violent. So go elect for your MPs. Now, what happens when you're violent in electing the MPs? Yeah, we just get rid of that as well, right? And you say, well, but we can't get rid of elections. They are not in Chapter 4, Chapter 16, right? So we can do it because we don't have to go to the people. In fact, we can even give back land to the white people, and you say, well, but land is protected. We'll use a notwithstanding clause. Notwithstanding the fact that we need to go back to the people, we're just giving back land because apparently we can. Now, I want to conclude by referring everybody to, I have more to say about this point, but I will reserve it for later. I want to refer everyone to the Ugandan Constitutional Court case of Mabirizi and others versus Attorney General. This is in 2018. The Uganda Constitutional Court was dealing with removal of the age limit of Yoweri Museveni, and they removed it. But Parliament in Uganda had also extended its term, wink, wink, from 5 to 7 years, wink, wink. And the Constitutional Court said, oh, by the way, and the term of Parliament was not an entrenched provision, right? So they did not need a referendum. And what did the Ugandan Constitutional Court say? I refer you to Uganda because it also has this conception of the power of the people being derived from the people. And the Constitutional Court said, well, yeah, it's not, your term is not entrenched. But what is entrenched is this power which is derived from the people. And you are simply extending for yourself without going back to the people. So even though that's not entrenched, you're affecting this. And that's what I'm telling you about elections, right? The election itself of the president may not be entrenched, but the right to vote is regular, free, and fair elections. Those are affected. Just as if you remove the Constitutional Court, what happens to my right to be heard? And perhaps in the interest of time, I can conclude there when it comes to removing the election of the president. And then we can continue for that and other provisions in the Q&A.
Thank you so much, Dr. Hofisi, for your presentation against the motion. Now, we will quickly move on, and my colleague, my fellow moderator, will introduce herself shortly to then lead us into the next segment of rebuttal. Nyasha, please do take over, if you're still with us.
Thank you, Farai. My name is Nyasha Matanda, and I am a law graduate, law with business, joint honours graduate. I am a speaker, an advocate, and a diaspora lead, as well as a multi-award-winning entrepreneur. I suppose I'll hand it back to you, Farai, to ask the first question. And
no, I think before we go into the questions, it's time for we have the rounds of rebuttal. So we're going to go 3 rounds of rebuttal. So we'll start with the professor. Professor Jonathan Moyo, after you've had a chance to hear what the motion against, what the proposition against your argument is, you have the right to reply. So we will do it, we will go 3 rounds, and then we'll go into the moderator's questions. Thank you. Professor Moyo, it's over to you.
Thank you, Farai. I wasn't aware that Dr. Hofisi is a musician who is actually out there in the market with an album. That is wonderful to hear. And
Prof, don't forget me as well.
Yeah, you get an honorable mention. Okay, thank you very much. You know, I was hoping you would kind of come up with issues that are of particular interest to yourself, yourselves, and your audience, because Dr. Hofisi, in my respectful opinion, was all over the place, mentioning all sorts of things. Sometimes in a debate like this, order might be helpful to focus our attention on particular issues, but I suppose this will happen when the audiences get involved. Be that as it may, and very quickly, I find that there are about 3 or so issues which were highlighted by Dr. Hofisi and are necessary to clarify. The first one is this whole question of a term limit provision, 1, in terms of what it is, and 2, whether amending it requires a referendum. I think the best thing to do is to follow closely what the Constitution itself says. Section 328, subsection 1 says term limit provision means a provision of this Constitution which limits the length of time that a person may hold or occupy a public office. It's therefore a provision that should make clear to you that person so-and-so who is an official or officer of a public office can only serve such and such time, maximum time. It limits, therefore it makes clear the time that an officer may hold or occupy an office. That is very clear. It means that when you are looking at a term limit provision, you must find in that provision a very clear, concise limit of the length of time. Now, when you go to section 95, it says the term of office of the president extends until following an election, he or she is declared to be re-elected or a new president is declared to be elected. And then it goes on to say, and except as otherwise provided in this Constitution, his or her term of office is 5 years and coterminous with the life of Parliament. 2 things become immediately clear to this one, on this one, regardless of who is reading it. 1, it answers Dr. Hofisi's question. I was surprised that he doesn't find the electoral cycle in this section, and yet it's so clear that the section says the term of office of the president extends until following an election. An election starts and ends the term of office of the president. Until following an election, he is declared, or he or she is declared to be re-elected. That's an election. How can you say you can't find an election when it is put right up front? Or a new president is declared to be elected. And then there is this proviso But significantly, as far as an election is concerned, this section goes on to say the term is coterminous with the life of Parliament. And the life of Parliament is provided in section 143, and it says clearly that this is a provision about the duration and dissolution of Parliament, and that the life of Parliament, or Parliament as an institution, is elected. And you say you can't say an election? Parliament is elected for a 5-year term, which runs from the date on which the president-elect is sworn in and assumes office in terms of section 94, subsection 1A. And then, of course, you can complete this as Dr. Hofisi helpfully did by looking at section 158, which then gives you the timing. The timing of election is the date of election. But the cycle of election is very clear from sections 95 and section 143, that these sections are dealing with the duration of each institution. One, the president's office, not the president himself, the office. This is why, because it's election-based, when there is a vacancy in that office, it is not filled by someone else who comes and claims a 5-year period. The successor claims only the remainder of the period that would have started by the election of the president and ends either by his or her re-election or the election of a new president. And that is tied to the life of Parliament. Why? Because the life of Parliament is subject to end even before the 5-year lifespan, which section 143, subsection 1 says it has. It can be dissolved sooner than that period. But even the president is not tied to that 5-year period. Section 95, subsection 2B is a contingent section. It depends. The president can be removed, he can resign, he can die, removed by impeachment, that is. But that doesn't end the time. That doesn't end the length of time. That's one thing. I think it's very clear that the electoral cycle in our constitution is defined by a reading, a harmonious reading of sections 95, 143, and 158. Those sections deal with the length of two institutions that come into existence by election. That is the office of president as an office and the parliament as an institution. Surprisingly, I don't understand why. Maybe he can help us and he can explain. Throughout his presentation, Dr. Hofisi didn't at all, not even once, given that he was preoccupied with the question of defining the term of office of the president. He did not look at the actual term limit provision of the president, which is section 91, subsection 2. It says a person is disqualified for election, that election which kickstarts the term, disqualified for election as president or appointment as vice president if he or she has already held office as president under the Constitution for 2 terms, whether continuous or not, and for the purpose of this subsection, 3 or more years. No limit on the ceiling, but a clear limit on the threshold of the bottom. 3 years equals to a term. There's nothing like that in section 95 because it is an institutional definition of the term limit. And because section 328 says that a term limit provision is one that puts a limit. Therefore, any provision that doesn't put a limit can't possibly be a term limit. What does it put in terms of a limit? It puts a limit on the personal tenure of the individual office holder, not an officer. Not an office electoral length or cycle, but the tenure of the office holder, that you have X amount of time to be in this office. Therefore, it also puts a maximum or cumulative length of time that a person may occupy, which Section 91 does very well. Section 92 doesn't do at all. Lastly, on this point, really, with all due respect, we cannot have a situation where a term or clause or provision that has been with us since 1980 under Section 29 and in various iterations and versions saying the same thing, defining what the length of the term of office of the office of president is. In 1980 to 1987, it was 6 years, but fortunately, although it was describing a ceremonial president, there was a limit there. It was a provision which a term limit provision was also built into a term length provision to say the president's term of office is 6 years and can be re-elected only once. When it came up in 1987 with Constitution Amendment number 7, there was no limit. It was an unlimited provision. It was worded exactly like 95 subsection 2B from 1987 to 2007 as a 6-year term of office with unlimited re-election, because it was worded exactly like Section 95 is worded. To now turn around and say something that we had in our Constitution for 33 years between 1987 and 2013 suddenly becomes a term limit provision, just like it was before, and it was not a term limit provision. And it was not a term limit provision somehow throughout that period, is actually quite strange. It's very strange that people can suddenly call something that we've lived with for that long, as is currently, suddenly becomes a term limit provision because it was made in 2013. In 2013, we got a term limit provision, and it is Section 91(2), the subsection 2, that is, which section Dr. Hofisi didn't deal with. Now, I hear that I have 1 minute, but I would like to ask you to take my other minutes from my time that you
with respect, Prof, you didn't
in order to make these points about two important issues. One, it is not correct that if you amend a term limit provision per se, you must have a referendum. I would like to ask Dr. Hofisi to assist the discourse by pointing to a section which provides that whenever you amend a term limit provision, you must go to the people to seek their concurrence. And I say this having in mind all the 10 subsections of Section 328. And there is no, because that is the section which defines or provides the procedure for amendment of the Constitution. None of them says that if or when you amend a term limit provision, you should go to the people. Secondly, Dr. Hofisi made a lot of interesting emphasis by focusing on the use of the non-obstante clause, in the bill, which says notwithstanding, and says that is evidence that there is awareness among on the part of the drafters that they are amending a term limit provision. No, Dr. Hofisi, it's not. The bill is not the first legal instrument to use this phrase. The phrase is being used for the sake of consistency, because that's a phrase that was used in 2021 when the Constitution was amended with respect to judges in Section 186, subsection 4, where subsection 4, after the provision affecting the Chief Justice, Deputy Chief Justice, judges of the Constitutional Court, and judges of the Supreme Court, it says, subsection 4, 186.4, notwithstanding section 3287, rather 328 subsection 7, the provision or provisions of subsections 1, 2, and 3 about those judges I mentioned of this section shall apply to the continuation in office of the Chief Justice, Deputy Chief Justice, judges of the Constitutional Court, and judges of the Supreme Court. And because the High Court in Musa Kika's case had interpreted the whole amendment to Section 186 to say it doesn't apply to the incumbents that I just outlined. And this is my last point about this, but I will return to it later because it's important. The court interpreted that to make it clear, and at paragraph 55 of the Mpungu judgment, the court said, the only possible interpretive difficulty that might arise in arriving to this question are that age limits are not term limit provisions, relates to the application of the non-obstante clause in section 186.4, which I just read. The phrase, notwithstanding subsection 7 of section 328. In this regard, I do not agree with the submission by Mr. Draukos that this clause modifies and amends section 328 subsection 7. No, do I accept the contention by Mr. Uriri that it operates to supersede section 328 subsection 7, for that would result in a glaring conflict between the provisions of section 186 and those of section 328. Rather, I'm inclined to construe subsection 4, the one which has the non-obstante clause, as having been inserted in order to clarify and reinforce the position that subsections 1, 2, and 3 in their amended form do not constitute amendments to any term limit provision. And that being the case, they remain applicable to the continuation in office of the incumbent judges identified in subsection 4. Here you can put the president, the MPs, those two categories. This harmonized interpretation gives full meaning and substance to section 186, subsection 4, without occasioning any infringement of subsection 328, section 328, subsection 7, and the restrictions on the continuation in public office that its provisions are designed to impose. I think that I would like to invite my colleague, fellow musician, Dr. Hofisi, to actually read the bill's provisions on clause numbers 4 and 9 together with section 186, the whole section 186 of the Constitution. The parallels are clear, the situation is very similar. So the clause is not there to overturn Section 328, subsection 7. It's there simply for clarificatory purposes, not for amendment purposes. Thank you.
Thank you, Professor. Now, what I'm now going to do is, because since we have a challenge with managing time, we were going to do 3 rebuttal segments. We are now cutting it to 2. So we're going to go for, Dr. Hofisi, you will respond with a full 10 minutes, which is congruent to what the professor did, after which the professor will come in to rebut, and then you get an opportunity to rebut again. We'll go to the moderator's questions. After that, we'll introduce our Q&A, so that we manage time wisely. So it just gives you sufficient time within that 2-round boundary to ventilate all these particular what you may deem to be contradictions towards your different arguments. But it also equally allows me to respect the time of our audience. That being said, Dr. Hofisi, the floor is yours for your rebuttal.
All right, I got 10 minutes.
Yeah, 10 minutes.
All right. Okay. So let's begin where he ended. So the professor is correct in reading that portion of the judgment. I invite everybody else who's listening, because Mpungu is available online. I am going to take a different approach. I will not read it verbatim, but I invite everybody to read the preceding paragraphs that lead to the conclusion that the professor refers to. That is to say, number 1, in Musa Kika, the 3 judges said there is an interpretive rule against regarding text as superfluous, as clarificatory, which the Constitutional Court then proceeds to do. But that's why Justice Batu is like, I'm in some difficulty here. What is the difficulty? Because you don't put a text that does not have meaning. And then if you read in Mpungu...
Excuse me, moderator.
No, if I could continue,
I can't hear.
Oh, okay.
I can't hear. I cannot hear. I really would like to hear what Dr. Hofisi is saying. Somehow I can't hear.
Okay. Can anybody else hear me? I'm not sure now. Hello?
Hello, Michelle, can you sort that out, please?
I can hear everyone clearly on my side.
All right. Can you hear me now, Professor?
Yes, at this moment I am hearing you. I wasn't earlier, but I can hear you now.
All right. Okay. Thank you. So as I was saying, I agree with the passage that the professor has read, and I invite everyone else to read the preceding paragraphs as to why the court reaches that decision. Because in an earlier paragraph, the court already agrees with Musa Kika. If the government is citing and overriding 328, they know they are changing a term limit provision. And the court said the court below was correct to apply that rule against superfluous text, I should say. But why does the court then say, okay, but this is clarificatory? Because the court says, well, this was actually not a term limit provision, which of course is the professor's provision, right? Position now, because the Constitutional Court says this is an age limit. If it were a term limit, then we would agree with the High Court, and the Chief Justice has to go because this provision is there. And I'm not the one who's saying the provision means that. This is emerging from the courts. Now, the court says this is an age limit, right? Time the bar is closing and not a term limit. Therefore, the Chief Justice does not have to go because he still has this 15-year term. And says because of that, this notwithstanding, that's the difficulty. So what does it mean? And the court is left to say, okay, it's clarificatory, right? And the professor is correct that if the court itself agrees with him that it's clarificatory, they need to be saved that way. However, the problem is that the judgment, which renders that part clarificatory, is saying, well, but if it affected 95, this would be a different discussion. It's the same 95 that the professor will not agree with in Mpungu, but will agree with the clarificatory part. You see that he is approbating and reprobating. He will take the conversation which says, well, this is clarificatory, but he will not take the one who says it wouldn't be clarificatory if we were dealing with 95. If we're dealing with what the Constitution says is the term, right? So the reason for the court doing that move is the one that is missing from reading only that section of the judgment. The court has already agreed. Putting that section there, it means that they are changing a term limit provision. But the court simply says the government was wrong. They thought they were changing a term limit provision. We know better as the guardians of the Constitution. It's an age limit provision. Therefore, we can give a different interpretation. But if it was 95, and this bill is dealing with 95, they say it's a different discussion. So that's how I am within the judgment and not a portion of the judgment. Now I think I was pretty happy with something the professor said, which is the professor said the election cycle is a harmonious reading. And to this extent, the courts would agree with him, because this is why you codify a constitution. If a constitution is not codified, if you're in the United Kingdom, if you're in Saudi Arabia, if you're in Israel, Canada, if you have got these various sources of constitutional text, then you do not need a harmonious reading. The reason why you put everything in one document is that it all feeds into each other. One provision is aware of the other. So the professor says 95 is an election cycle together with 158 and 143. Of course, I disagree with his inclusion of 95 because the Constitutional Court disagrees with that view. The Constitutional Court said 95 is a term limit provision because it has got the unit of time. And 91 doesn't have the unit of time. So the Constitutional Court had already looked at 91 and said, where is the time? So if you look at all the term limit provisions by the Constitutional Court, there's a unit of time. And because there's no unit of time, it can be varied. 91 can be varied. So 91 then becomes like the age limit, right? If we were to take the reading by the professor, if you can always vary the time, but what's the unit of time, the length of time? And that's my read from 95 pretty clearly. The fact that the term is 5 years with some exceptions, right? But the exception doesn't define the rule. The rule is that the term is 5 years. So harmonious reading, Professor, I would say, through you, Chair, is what accounts for what you're talking about, section 91 and 95. If you do a harmonious reading of 91 and 95, you understand the full extent of the term limit, and constitutions are always read harmoniously, as you have said. Max Mpungu says so. There's a rich history. Holet, going back to Holet, Trangila versus Mugabe. The constitution is read as a whole. So it's not possible to separate, in my respectful view, 91 from 95 if we are to stick to the canon of interpretation. Even though I am aware this is a debate, we're not in a court of law, but speaking to a judgment, I'm speaking to how courts would deal with the canon. So that's how I would respond to those terms. And I would want to hasten to say the mentioning of an election doesn't render a provision an election cycle, which is why I did ask the professor, how is he defining this term? I think I gave my definition of the term of an election cycle, the interval, the period within which elections must be held for a position. And I think I'm still wondering what the definition is using for election cycle, since we do not have, I believe, that definition in the Constitution. I've not seen it in any court judgment. This is the one I came up with by looking through some authorities. I don't know what is his though. I'm curious the definition of election cycle that he's using. Now I want to use the remainder of my time before the rebuttal comes to kind of add some of the things that I have not mentioned. So if you look at the bill, the professor just told us the dates from which that cycle occurs. I can't find those dates in the bill. Are they in the bill? I don't see them. I heard that same framing when the minister was speaking to the media, but does the bill say that? I want to know what's his source for saying it's for September back in 2023 until 2030, because I cannot locate that. What is the authority for that? And when you look at the bill, who is going to be electing this president in parliament? The bill doesn't tell you when. I'm saying I can't find it, but I have the bill here. You can point me to where. And it says the election is by ZEC or a designated judge. Why is there the option of a designated judge? Why and who designates the judge? And why is a designated judge doing that and not ZEC? What are the qualifications for that judge? I don't fully understand the process, just from a process standpoint, that who is the one who is actually doing this. The professor said, show me a provision where it says amending a term limit provision necessarily requires a referendum. I don't believe there is one, which is why I did not say that. I said the requirements for a referendum are 3. I said rights, 4 and 16. I said changing the term limits to extend incumbency, right? Extending incumbency of a term limited provision and changing the amendment rules. Those are the ones for which you need to come back to, and you need to come back to the people. And I do want to add also, when you say that, how can we suddenly think of what was in the 1980 Constitution up to 2013 as being a term limit provision? Yeah, I'm saying we do now, because that's how the Constitution defines it. And in 1980, we did not have that definition, right? So in the four corners of the 1980 Constitution, yeah, that would probably not be, depending on how it defines it. I haven't located where, if that Constitution defined a term limit. But in this context, for the 2013 Constitution, a term limit is indeed anything that limits the length of time that a person can hold or occupy public office. So by the current Constitution, yes, Robert Mugabe was term limited. He had renewable terms, right? And the term limits now are non-renewable by this definition. And I do not understand whatever conception that was in 1980 as having any bearing on the conception that is in the 1980 Constitution itself. And perhaps I'll conclude. I think I have just about 1 minute left to say the real mischief for removing the presidential election is violence. That's your view. I have a different view. I believe the real mischief is to deal with the reality that I believe there is some norm that if you are within the presidium in ZANU-PF, you are like a Supreme Court justice in the United States. You serve on good behavior until you die. You remain there. But you have this problem where the Constitution requires the president to leave office, but the rest of the ZANU-PF presidium, they still retain power, but he has power over there. That's the real center. So as far as I'm concerned, that's the real mischief, that you have tied in one officer, the most powerful in a party, right? And so all of the subordinates can continue as ministers, but he has to go. That is the mischief, right? The fact that we have this mismatch between the party and the country, kind of why there was that Thabo Mbeki situation, that he wanted another term at the ANC, but the state is different. As far as I'm concerned, that's the real mischief. I think I'm out of time.
Thank you, Dr. Hofisi. I will now segue into the second part of the rebuttals, and Professor Jonathan Moyo, you can go ahead and start the second stage. Thank you.
Thank you very much. There are some questions that Dr. Hofisi has raised, which I believe require a straight answer. First of all, I'm surprised, Dr. Hofisi. I appreciate your invitation to the audience and all of us to read the Mpungu judgment and the relevant provisions of the Constitution. I can assure you, I for one, I can't even tell you how many times I've read the Mpungu judgment. It is, with all respect, not correct that the court, in that long, famous paragraph, which is obiter, an opinion that the court is giving, the one that starts by saying, by way of contrast, the Constitution abounds with a myriad of provisions that unquestionably constitute specific term limit provisions within the parameter of Section 328. First and foremost, there is Section 95, which expressly stipulates that the term of office of the president is 5 years and coterminous with the life of parliament. Full stop. This is the only sentence, one sentence you find about Section 95. And people argue that this section, which is part of an obiter paragraph, which is not part of the operative or binding judgment of the court, has dealt with Section 95. And for that reason, we must shut up and not point the obvious as thinking people that this is not correct, that it is not correct or reasonable or possible that you can cite Section 95, subsection 2, which is the old Section 29, or in the former Lancaster Constitution, as a term limit provision. This was with the Constitution all these years, and it continues. But what is new is Section 91, subsection 2. It's like claiming that before the 22nd Amendment in the United States, Article 2 that said the president has 4 years, the 4-year election cycle was not a term limit for 163 years, but it became a term limit in 1951 when the 22nd Amendment was adopted. I really would like to see where the logic in making this claim is. Just because a court has, in passing, made some remark, it doesn't mean we then take that remark lock, stock, and barrel as the new gospel and the holy grail, when quite clearly it simply can't stand. It was not argued by anyone in court. It will be argued now in these cases that are coming. And if we are still reasonable beings, informed by history, informed by rationality, there's no reasonable court which will actually, in an operative part of its judgment, say that Section 95, subsection 2 is a term limit provision. It clearly is not. Why is it not, Dr. Hofisi? It is not a term limit provision because it doesn't put any limit. We can recognize a limit where there's one. The Constitution has 15 term limit provisions, and we can find what is common, what relationship they have with one another, and critically, what differentiates them from other provisions which are not term limit provisions. We can't keep arguing about term limit provisions focusing on one when there are 15. The court cited 10, one which was wrong, the other 9 are correct, but there are 15, and they are not all about the president. They are even about commanders of the defense forces, about permanent secretaries, about the judges, as we saw in the other example. Now, for us to talk about a term limit provision as if only the office of the president as a term limit provision is, with respect, irrational. But even more irrational is to ignore the fact that the only provision which was introduced as a term limit provision for the first time in our Constitution since 1980 is Section 91, subsection 2. It's a clear term limit provision, is similar to term limit provisions in other jurisdictions that are comparable to Zimbabwe. And when you say it doesn't have time, it doesn't make reference to time, I'm at a loss as to what that means and where that is coming from with respect to Dr. Hofisi, because it says a person is disqualified for election as president or appointment as vice president if he or she has already held office as president under this constitution for 2 terms. This is the only section which tells us how many terms a president is limited to. Section 95 doesn't even tell us that is limited to 1 term. There's no limit. This one limits the president to 2 terms. And the 2 terms, the last time I checked, was a reference to time. And in this case, the section doesn't leave us doubting or not knowing what a term is or what sort of time a term is, because it continues to say these 2 terms are counted whether they follow each other or not. But more significantly, for the purpose of the limit on the president, the term limit on the president, which is provided in this section, 3 or more years, that's time. You said there's no time here. 3 years is time. The length of time is 3 years minimum. And the maximum is more. Is not defined here. It's 3 or more years. It's more because that is subject to what the relevant law about electoral cycles says is the electoral cycle of the institution that the president occupies. And talk about this institution. I'm a little bit puzzled, Dr. Hofisi, to hear you saying that the the clause 3, which introduces a direct election of the president, is killing and is taking away an institution. That can't be possibly true, because the institution of the president is the president's office, the president of the country, the executive president. There's nothing in the bill which takes that institution away. What is happening is a change of the election method, a change from a directly elected president in this important institution to an indirectly elected by electors, elected by the people, and these electors being members of the National Assembly and the Senate sitting in a joint session for the purpose of electing a president as an electoral college. And to argue that somehow that this has killed an institution.
We've got 1 minute left.
Is a stretch, So with 1 minute left, I want to answer a question you asked. What is the definition of electoral cycle? An electoral cycle is the period between an election, one election and the next election. That is a cycle. That is defined in Section 95 as a 5-year period, which is coterminous with life of Parliament. That cycle repeats itself in terms of sessions. Zimbabwe right now has had, if you go by the Parliament, 10 cycles. That's why we have the 10th Parliament. The presidential election was disconnected from Parliament in 1990, and we had we've had 7 presidential elections. But between 1990 and 2008, they were occurring as an independent cycle, and the cycle was 6 years. Every 6 years, the section equivalent to 95(2), which was Section 29 of the old Constitution, was defining that the president will be elected every 6 years, every 6 years. Now, from 2008 and fortified in 2013 with the new Constitution, that changed from 6 years to 5 years. It became coterminous with the life of Parliament. It is a cycle which repeats itself. It's a cycle which makes clear to the Republic when does this office start and when does it end. And in between, when there is a vacancy, we don't kickstart a new one. We continue to fill the remaining period by a successor. And significantly, Dr. Hofisi, I would invite you to pay attention on the phrasing of subsection 95, subsection 2, section 95, subsection 2B, which says following an election. It means after an election. The clock starts after an election, and it ends when the president is re-elected or a new one is elected. When does that happen? It happens at the end of the cycle, which is 5 years. This is a cycle of an institution. It's not a cycle of the individual, because we know already that a term for the president, for purposes of the term limit, is 3 years. And you can't then point to a phrase.
Would you like to round off? Sorry.
Sorry?
Your 1 minute is up.
Well, it's down on my side.
Okay. Would you like to round off? That's absolutely fine.
No. I'm a creature of instructions. Since there will be another opportunity in the questions or the summary, I will bring. I think the main point has been made. Thank you very much.
You have the opportunity to bring it back when we have more questions.
Sure, I appreciate that.
Thank you, Professor. Dr. Hofisi, would you like to respond to what Professor has mentioned?
Yeah, absolutely. So, interesting. A professor is making a reference to obiter dicta. I also want to know what is the professor's definition of obiter and how is he applying it to the definition of 95? Because
You know, colleagues, I don't know what happens.
okay.
I hope there are no gremlins, because each time Dr. Hofisi starts speaking, some gremlin comes to shut me out. I really want to hear him. Help me hear him. I would be most grateful.
Yes. Michelle, can you just double check, please, for us?
Everything's still coming through from the side.
Okay.
Maybe what we could
Can
do
you hear
is.
me?
Can you hear me? Am I audible now?
Prof, can you hear?
Professor, can you hear me?
I'm hearing him now, just saying those three words. I hope I will hear him in full and completely.
Okay, let's give it a
It
go.
seems there's a bit of a delay, but yeah, you can carry on, Dr. Hofisi, please. Thank you.
Sorry, excuse me. I'd say, Professor, I'm very interested in your definition of obiter dicta and how you are applying it to Mupungu, because ratio decidendi, reasons for the decision, my understanding certainly is that obiter are the things that are mentioned that are not necessary for the court to reach its decision. Now, if it is a case in which the court has to distinguish categories, then the distinguishing of categories is part of the rationale for the decision, because the court was making a claim that an age limit is not a term limit. And then it was showing us why. So this is the courts showing us its rationale for reaching the decision. And the rationale is that there are term limits, and then there are those that are not. Here are the term limits. Here are their characteristics. Look at this age limit. It does not have those characteristics. Therefore, we must reach the decision that the age limit is not a term limit. So the definition of what is a term limit and what constitutes a term limit becomes, as far as I'm concerned, the reason for the decision. Obiter, for me, is like if the court is talking about the powers of the presidency or something which it does not become a but for reaching the decision. So I certainly disagree there. And you made reference to the 15 term limits in the Constitution, and you say, why are we talking about just one? I presume that is the one from the Attorney General's office. I do wonder if you look at part 4 of that list of term limits, which includes that Supreme Court justices have got a term limit of retirement at 70. Do you agree with that? I'm not sure I do. And you will notice in that list that they do not include that Parliament has got a term limit. As I've said, the bill treats Parliament like it's got a term a limit because there is that override. Now, going to section 91, in section 91, you say the reference to term, you say there's 2 references to time. Term, which to me is a period but not a unit of time. And then secondly, you say 3 or more years. Now, and that is not what I understand to be a unit of time that limits a term. That is a limit, that is a minimum that is being used for purposes of that subsection to calculate what will be deemed a full term, right? But what is going to get you out of office is the fact that you have been in office for more than 3 years. In fact, at 5 years, that is when the term is well and fully deemed. But if you have served 3 years, it will be deemed that way for further calculation. So there is a distinction between minimum and maximum there, right? That's what a term limit is. This is the time at which you have to go, just like all the other term limits like that of the judges, where you serve not more than 15 years, right? So whatever the minimum is, but the limit is the 15 years, right? That's the amount of time for which you have to go. And notice at 3 years, the one you're saying in 91, you do not have to go at 3 years, right? You're not term limited at that stage, right? But it's going to be calculated for the future, but you can be in there for 4 years, 4.5, 5 years. So you are not term limited at 3 years. That's a minimum. There's a real distinction there between the option to leave and what that means for deeming something, and actually the requirement to leave, which is what a term limit does. And require is the word that is used in Mpungu by the judges talking about that requirement to leave. You are certainly correct that this is not getting rid of the institution of the presidency. It is getting rid of the institution of the presidential election. It is getting rid of the institution of citizens holding the chief executive, of the country accountable in a direct way. It is getting rid of that moment after every election where like, this is what I wanted the local authority, this is what I want for parliament, now this is what I want for the chief executive. That institution is what has been gotten rid of. And what you say is an election cycle is the period between one election to the next. So certainly for me, the way we calculate the period from one election to the next is what we get from the timing of elections, which is why, as I had pointed out, if you go to 158, it's going to tell you the timing of all elections. Local authorities that you referenced, that's in 158, that they have to be together with the president in parliament. And when is that parliamentary election? It's all there in 158, which is why, as far as I'm concerned, that is the election cycle. And I presume the court was aware of this. Now, I don't know how well I am doing for time, because I am actually desperate to add a few other things, such as the fact that we know that the executive presidency, how much am I doing? How well am I doing for time?
Another 5 minutes, Doctor.
Okay, in these 5 minutes, I want to point out the executive presidency is something that the Patriotic Front wanted in 1979. Okay, the conception of this indirect election is something that is in Lancaster, that was foisted by the British. Zimbabwe isn't the only Lancaster constitution. The constitutions of Nigeria, Uganda, Kenya, Mauritius were all negotiated at Lancaster House, and they all have indirect elections. If you look at every constitution that was bestowed by Britain as the decolonizing power, it has indirect elections. And do we think maybe that is because all these Africans just wanted indirect elections, or it was a precondition that Britain would not grant independence unless you accepted unless you accepted indirect elections, which is precisely the reason why anybody who wants to look this up can Google, because this article is online, so I didn't have to go to the archives for this. The article, Rhodesian Split on British Proposal Threatens Peace Parley in London. This is by R.W. Apple Jr., special correspondent to the New York Times, published 15 September 1979, who says, and I quote, "Meanwhile, the bishop's foes, that's Muzorewa, the Patriotic Front Guerrilla Alliance, published their own proposed independence constitution tonight. It does away with guarantees for the white minority altogether. It contemplates an executive president with extremely broad powers, not only in civil areas, but as head of the armed forces," unquote. And this is the reason why, if you listen to Edson Robbo, Justice Minister's speech on 3 November 1987, during the second reading of establishing the executive presidency, he gives 5 reasons why we are switching to that. Number 1, he calls it the African system, distinguishing it from the UK, which is entirely in parliament, or the US, where the president selects from outside parliament. It is African. And number 2 is for political stability and effective leadership to represent the whole nation, right? And not a faction of it. Remember, it's the 80s. You've got Gukura Hundi, you've got, establishing a 5th brigade. Do I trust everybody over there? But then now we want someone who represents the whole nation. Number 3 is to avoid structural conflict. 4 is to remove that artificial division of a titular executive and the power of government. And number 5, this phrase that the late Robgo uses, reducing democratic distance, right? So because the parliamentary system then allows for these, what he uses this term, sectional, regional, and tribal interests. So to deal with that, we need to shorten the democratic distance, not make it indirect, and have someone who is accountable to the whole country, right? Not just someone who is accountable to their clan, right? To the people they speak to. But if the whole country is electing you, then you're accountable to the whole country. So you build national unity. And this is why, at least if you read the Hansard, that is the reason. And even the current president of Zimbabwe, was Minister of State Security, also says, and I quote, that the bill is clearly testament to the party's irrevocable belief in people's will, right? That it expresses the democratic aspirations of the Zimbabwean people in one fundamental respect, their right to choose and elect a president of their own choice through the popular vote. This was on 30 October 1987. So the reasons that we established an executive presidency are rooted in these characteristics, right? We want a president to be responsive to the whole country. Everybody gets to vote. And we do not want to get to the Lancaster arrangements where it has to be indirect, where you cannot even access land. Now, do I have 1 minute or none?
You have 2 minutes.
I have 2 minutes. I want to switch the conversation, though, and talk about the judiciary and highlight to everybody that if you look at the judiciary in Zimbabwe, currently, the president appoints the chief justice, deputy chief justice, and the judge president after consultation with the Judicial Service Commission. So that is to say, the president has to consult the Judicial Service Commission. He does not have to be bound by the advice. But if the president appoints any chief justice, deputy, or judge president against the advice of the Judicial Service Commission, the president has to inform the Senate. That is what we have now. Secondly, for promotions in one tier, so from Labor Court to High Court to Supreme Court to Constitutional Court, the president can make those appointments without public interviews, only on the advice of the Judicial Service Commission. So the JSC is the employer, says we have done our performance appraisal. This person is performing well, they can be appointed only to the next level, then the president appoints. And for everyone else, it's public interviews, right? And this is how you constitute this judiciary deriving authority from the people, not only through a president who's directly elected, so you deal with the counter-majoritarian difficulty, but also the fact that people are involved in appointing these judges. Everyone can nominate a judge. It's public interviews you all watch. So what is the bill doing now? First of all, the president is no longer required to report to the Senate, right, when it does not follow the advice in appointing the chief justice, deputy, or judge president. No longer needs to follow the advice of the Judicial Service Commission for promotions up to 1T, and no public interviews for any judge. So now the president can appoint myself right to the Constitutional Court tomorrow without any experience within the judiciary, and there's no filter that was there through the Judicial Service Commission with the appraisals as the employer over time. There's no public process for people to know. So there's a real question of how the judiciary is deriving this authority from the people now. When there's no public participation, it's all been removed. The president himself is not directly elected by the people, but is the one who has all these massive powers to just appoint the entire judiciary, which is supposed to be deriving from the people. So the president, elected by parliament, will appoint members of the judiciary, and the judiciary will be evaluating, right, the laws that are made by parliament, which is directly elected by the people. So what you have done, you have supercharged the counter-majoritarian difficulty. Why must a court, and perhaps this is actually the whole point of stripping this power from the court and then pretending to give them back by giving them the power to assess matters of public importance. Why would a court have the power to strike down laws of a directly elected parliament if the courts are unelected and the president is himself elected by the same parliament that is passing those laws? So it's a structural oddity, or to use the word the professor used, a strange one, in order to come up with a judiciary like this and still say we are looking to South Africa for how we are modeling the president, right? And look to South Africa to give the courts this power for matters of public importance, but strip away all the manner of appointing the judiciary that we get from South Africa. Thank you. Unless I have time, I can go on, but
Thank you so much, Dr. Hofisi. And thank you so much, Professor Jonathan Moyo, for your candid debate that has retained a sense of decorum and a diplomatic approach to a very important subject matter that indeed is consequential. So we are going to move on to the next segment, which is much more of the editorial aspect of it, where we, the Southern African Times moderators, begin to ask questions in relation to the argument that you guys have laid from our understanding. And so I'm just going to briefly start. I'm going to deal with the good professor, and my colleague will deal with you, Doc. Now, Professor, you have argued that Section 95(2) is a procedural and rather than fundamental. Yet the bill also proposes broader structural changes, including how a president may be selected. At what point does a procedural amendment become a substantive redesign of democratic choice? I suppose the interplay here is really focused on the concept of referenda that we are simply saying is absent. I think we need clarity on that.
Yes. Thank you. Quickly, with reference to the referendum, for the first time since 2013, the issue which previously was up to political players, as was the case in 2000 and in 2013 itself, where the ruling parties, ZANU-PF and the two MDC formations, agreed in the GPA that there would be a compact process and that it would produce a draft constitution, and that constitution would be presented or submitted to a referendum as a political agreement was possible. But they put to a referendum a draft constitution, which is now the fundamental law of the land, and which must guide government and every person, and has been doing that since 2013. That constitution now is the reference to when do we have a referendum, on what questions we will have a referendum. And it is very clear, and Dr. Hofisi made this very clear on a number of occasions in his presentation, that it applies to rights, fundamental human rights in the Declaration of Rights, Chapter 4, and fundamental rights to the land we reclaimed during the land reform program, which is Chapter 16. And significantly, to how we amend this constitution, which is in Section 328, and nowhere else. You can't say, let's have a referendum outside the provisions of the constitution because you want one, because it assists your political program, or whatever reason. It will help us. People say repeatedly that we need to strengthen the rule of law, we need to strengthen the institutions of the state, be they direct agencies of government or those we incomprehensibly call independent commissions. Now, for people to say, let's have a referendum just because they don't like something or they don't have representatives or members in parliament whom they think they will represent them, or because their political lives were dying and they now want to revive them, as is wont to happen in Zimbabwe, as far back as one case to review, that when there is a change or a suggestion that we're amending the constitution, we have compatriots who now begin to think that opposing for the sake of opposing, even things they supported yesterday, like the movement, the transfer of the voter registration from ZEC to the registrar department, is something that there's a record in parliament which shows that the people are now opposing it, in fact, supported it. So let's be clear. A referendum is a very important mechanism that is in the Constitution, which was put to a referendum in 2013 to say it shall apply only when we are amending Chapter 4, Chapter 16, or Section 328. The question of whether Section 95, subsection 2B, is a term limit provision is the one we continue to argue among each other, as we are doing with Dr. Hofisi. If that section is a term limit provision and it's amended as proposed, and it therefore affects subsection 7 of Section 328, then a referendum arises. But it can't arise because someone sitting somewhere thinks that it should arise. I have argued, and I am fortified in the position that a court of law will sustain this, but we are not dealing with a court of law. We are dealing with making law, and Parliament is fully within its rights to make the law, and the Parliamentary Legal Committee does not have power to review that. I'm fortified that in the understanding with clarity of mind, as someone who was a lawmaker for more than 20 years in our parliament, that this is within parliament to make, in terms of subsection 5 of Section 328.
Just in the interest of time, I want to move on to my second question. But I suppose the passing comment would be that if one is to assume the claim that your opponent made, that this is an entrenched provision, then perhaps the argument then makes sense, perhaps not necessarily coming from the court as you're suggesting, but purely from a citizenry question point of view, who helped draft that particular constitution.
Yeah, I just want to say, Farai, an argument, a declaration or a claim does not become binding or correct just because A or B is making it. You
No, I
know,
suppose the
we
premise
hear
of
those.
the premise of
So,
my, with respect to Prof, the premise of my pushback is not necessarily about, because remember initially your preamble to answering my question was that the assumptions being made are sourced from people with these particular inhibitions, be it they oppose it because of their failing political lives. I am simply saying that perhaps there is equally a source that is citizen-based, that has no interest in
well,
anything
but
else but purely
the
this.
citizen source has to abide with the Constitution.
Sure.
They
No,
don't
so in that
become
regard, then we can move on to my
constitutional.
second question. So my second question is this. Now, you alluded to the element of how did you put it? I think you framed it as stability, a question of stability. You cited moments moments of citation. You pointed to a historical, and you said that this particularly helps for consistency and a sense of stability and so forth. The question for me is, what informs that? What data sets have we looked at to justify that proposition from a
Yeah,
local perspective?
yeah. The presidential election, in particular, since its introduction in 1990, and we've had 7 elections since then. Each and every one of them has been characterized by perennial disputation of both the conduct and the outcome. And some of them have been so violent that ended up putting Zimbabwe at the behest of the British government then as an agenda at the United Nations Security Council, and we faced real sanctions, not those like Zidera, but real sanctions under the UN Security Council. But for the double veto by China and Russia, risking national security, national interest by one election. However,
I suppose, Prof, my question is, if I can just slightly push back, you're citing events. You're not citing any evidence that the alternative to
I'm
what
citing what?
you're
Citing what?
citing events.
No, this is,
These are
you think that the 2008 election was an event? You mean
well.
you are the only one who doesn't?
No. Okay, it's an experience. However you want to describe it. The point I'm trying to make is that the question is, what would the antidote you are proposing for this particular stability is that we are to change our entire political framework. Yet that very same constituency went to a referendum. Over 80% of the people voted for this particular condition of a constitution. Then what is
Yes.
to suggest, therefore, by evidence, that this will make things better?
Yeah. Well, first of all, the parliament and the vote that took place in 2013 was not for all times. It was for that period. And that's why within the Constitution, there are procedures for amending it. And when those procedures are being followed, you can't keep referring to referendums of the past as if they locked and tied future parliaments. So we have to be very clear about that. It is an unconstitutional position to try and pick a particular moment and the decisions of that moment as for all time.
Professor, the very premise of your argument is based on particular moments of historical
No.
experience.
No. They are not based on my position. Does not treat every event or any event as a constitutional event. We must distinguish what the Constitution provides and what generations or communities from time to time in terms of prevailing interests decide to do. I want to give you very quickly 2 data-based possibilities that could happen under this presidential direct election executive presidency. And I want to preface that by reminding Dr. Hofisi that it's well and good to read the Hansard. But the Hansard, they have just opinions of people who are debating. The decisions are in the law as then it is adopted. And you don't see those arguments. But when we look at the decisions in terms of Constitutional Amendment number 7, which introduced the executive presidency, we know for a fact that this was not about promoting democracy for everyone. This was about consolidating a one-party state, and this is not unambiguous. This is in the text of the Constitution. And we know that much of that has remained the same. In fact, was not even touched when the current Constitution was adopted in 2013. That we actually have a fairly rights-based Constitution.
But Professor, if it was about a one-party state, you argued that and won in the 90s, did you not?
No. But the de facto reality and the Constitution didn't change. The Constitutional Amendment number 7 anticipated a one-party state. And when the one-party state failed, de jure one-party state, the de facto one-party state succeeded because of the executive presidency in the manner it was shaped right up front in 1987. I appreciate your
I apologize.
I really want to make a point here.
Just push back, but please go ahead.
You're welcome to you're welcome to push back, but I want to push back also to make these 2 points.
Sure, please go ahead.
Point number 1, as it is currently structured, the executive presidency can have an election decided by 4 provinces, just 4 out of 6. And that possibility should give all of us a pause and wonder, do you really want a system that creates the possibility of 4 provinces conniving against 6 provinces and winning the election? Is that consistent with Section 3(2)(a) of our Constitution, which aspires for a multi-party democratic political system? I don't think so. Also,
but you were in government when we did adopt this particular Constitution. Why was that not the argument?
No, I mean, the moment you personalize national issues in this kind of way, you become unhelpful. You become unhelpful. Do you think if I had argued this, assuming you are correct that I didn't argue, do you think if I had argued this, that would tilt the question and made a difference?
Perhaps it would have not made a difference, but you had
I think this Zimbabwean thing of personalizing issues. You want to put the whole Constitution on my shoulders? We are making arguments here.
I dare not. I'm just curious to see if you made the case.
Yeah, but it will not affect the price of rice in China if I did or didn't. But sure. There were lots of arguments, and I would like to keep it at the institutional level and not at the personal level. And I'm saying, I just want to conclude on this point. And I'm saying, and this is a very important point, you have a constitution whose election method for a president based on the executive presidency as it has been with us since 1987 makes it possible for populous provinces, only 4 of them, to choose a president. That is not a far-fetched thing. It's a real possibility. And I'm putting it to you, and especially to Dr. Hofisi, that it is not in the interest of unity, in the interest of national cohesion, in the public interest, to be faced and saddled by a constitution that makes such a thing possible. Lastly, the same constitution, in terms of the method of electing a president, makes it possible for someone who is an independent candidate who doesn't have a single member of parliament to win the presidency, purely because of how it is designed. It's not if the Constitution of Kenya took care of those things by requiring a minimum number of regions for someone to qualify for the presidency. This one doesn't. And you know, if you win as an independent candidate and you don't have members of parliament to, at the very least, pass a budget, then that can't be in the national interest when you have an independent winner with no reliable MPs. It would create a practical governance problem that is highlighted by the problems that flow directly from an executive presidency, which becomes the only important office in the land, which becomes because when you have this orientation towards an election mode, and the government begins to react with a default position of a survival mode, then you get all hell breaking loose. Patronage, ethnic mobilization, incompetence, inefficiency, because when survival becomes the dominant thing, then you create problems. So I leave it up to you. The history of this institution, by the way, in 2023, we almost found ourselves in trouble just because some SADC election observer mission took issue with the way, or claiming that it was taking issue with the way the election was conducted, when that mission we had something like 12,000 plus polling stations. They observed 172 polling stations. And came up with a report which almost decided elections.
Prof, for the sake of time, I think you can add that to the closing argument. Let's add that to the closing argument.
What are you saying about the closing argument?
I'm saying that maybe we can add that, the last point you're making, maybe we can add it to the closing arguments. I've eaten into Nyasha's time, so I'm cognizant of that. Well, she would need to do her moderating questions for Hofisi. So I do apologize.
But I hope you realize the implications of having the possibility of 4 provinces conniving and conspiring.
No, I do realize
and this point that just by dint of a report which was based on 172 polling stations, I think there are something like 1.3% of the polling stations to decide a whole election. I think having an election system which is vulnerable to the internal problems, like I have outlined, and then creates a window for external interference and sabotage of the republic, surely can't be in the national interest.
I think
it has nothing to do with there's nothing to do with the British and their parliamentary system.
With respect, I really must hand over the time, and we can talk about this further, but I suppose as a closing remark to that point, I think at the end of the day, we still had a referendum that decided the outcome that we currently have. The conditions were quite described in that 2013 referendum. And so we can tackle that in our closing remarks and explore this further. Over to you, Nyasha.
Thank you, Farai. So, Dr. Hofisi, I've got the first question here for you. So, in recent writing, you described Bill number 3 as fundamentally altering democratic accountability. However, in earlier commentary on amendment number 2, you suggested that some structural changes did not necessarily amount to unchecked presidential consolidation. What for you is the threshold that transforms a constitutional amendment from contestable to acceptable?
Okay, quick answer is it's a change that respects the rules of how the constitution must be changed. And my biggest fear is that this is not respecting the rules. It's coming up with innovative ways to push back against the judiciary. And because of that, because I don't feel the rules, I don't feel there's a good faith commitment to following the rules. And for me, that's essentially the problem, because as I said before, the rules to change this constitution, that's the hard drive of the constitution, right? That's what the constitution runs on. When the constitution tells you how to change the constitution, and people are coming up with creative ways to avoid what the constitution requires. So which rule will be respected? Well, what that means is that the rules that will be respected are the ones that will come out of parliament, which is what I'm reading when the professor is referencing this sovereignty of parliament, that the referendum cannot bind parliament. And I agree, and I'm saying that's a frame I agree with. If you're a parliamentary sovereignty, that is true. You get to make the rules. But if it's a constitutional constitutional supremacy, constitutional democracy, then parliament has to in some ways be subject to the constitution and its rules. And as you are saying in the Second Amendment, I personally, and I'm going to say this, and I know a lot of people who came after me when I was perceived to be doing writings and the bidding of ZANU-PF, some of them will be happy with what I'm about to say. That is certainly with the Second Amendment, I do feel like I was playing a fool somewhat. There's a story that people talk about in respect of a cold winter's night in the desert, and there's a camel, and there's a gentleman in a tent, and the camel just says, "Hey, I just need my head first, just my head. I'm cold." And then later is the first hump, then is the second hump. And by the time you realize the camel just wanted to get into the tent, you're out of the tent, but it's too late. And I feel that way about a lot of these changes, where in the beginning we are told, hey, we've got a vice president who is a running mate, who takes over from the president. It's postponed for 10 years, the constitution is passed, and then it's removed, right? This is what's happening. Like with judges, we're first told, hey, it's just the chief justice, we don't want a senior being interviewed by juniors, just the deputy and president. And then next is no, just promotions by the judicial service. Now it's no interviews for everyone. And it's this sequence, right? So if you read each amendment on its own, you're going to end up like the gentleman in the tent. And that's what I'm pointing out here, that the prosecutor general, first it was, we don't need public interviews, but it would be on the authority of the Judicial Service Commission. Now that has been removed also. It is this sequencing that is making me realize that it is myopic of us to read these amendments for what they are doing now, but we should be asking, what's the plan, right? What's the plan? Are they really changing this constitution fundamentally to remove presidential elections because they want 2 more years? Or is it more than that? What are they building towards by ensuring that the president is the one who chooses the person who is keeping the voters roll, doing registration, doing delimitation? What is the point of allowing a president who is unelected to appoint more senators? Now appointing 10, it was just 5, right? But in the past, we're like, no, the president was elected by everyone, so they can appoint a few, but now is appointed only by parliament and gets to appoint even more. What are they building? That is a different structure, particularly if you are electing, if parliament is electing the president, but parliament cannot remove the president on good behavior, right? Impeachment is if the president does something wrong. It's a charge sheet. But parliamentary democracies, right? UK, Canada, vote of no confidence, even South Africa. We're just not happy with what you're doing. You haven't committed a crime, but we elected you, so we remove you. But our parliament won't be able to do that. They just elect the president, they don't remove the president. But even more importantly, because I love what the professor is saying here, like I'm a great reader of the professor's work. Like I have his book and I bought this personally. This is not from the library. And his idea from Kenya, that is true. In Kenya, you don't just get more than half the votes. You need like more than half votes cast in at least 25% of the counties. Great idea. Why didn't we start a discussion about those things if we really wanted to build a sort of national sentiment towards making these changes, rather than it's introduced and everyone is just forced to follow suit? So that is in fact the problem, where you have this president with enormous powers. The parliament elects the president cannot remove them. So the professor is saying, and I want to know, right? Don't we all want to know which these magical 4 provinces are? Like, we want to find out what the professor is talking about. But how is this bill addressing what the professor is saying? How does the bill address that question of 4 provinces? How does it move us closer to that Kenyan model? And I would be happy if we're having those sort of discussions and the bill was moving us in that direction. Currently, and that's why I have a problem when people refer to the United States, which is an indirect kind of election, because the United States has 50 state elections. There's no national election. Each state decides. But within each state, the electors have to vote what the state has decided. It's winner take all in 48 of them. In Maine and Nebraska, 2 is winner take all, and the remainder it's whatever that county has decided. Now, in this sense, I like what the professor has said. Is the constituency the one that is electing the president? Look through the bill. You will not find the answer. Is the member of parliament bound to vote what the constituency has decided? Or does the member of parliament just decide, hey, I think this is what's in the best interests of my constituency? Who is doing the election? Is it the constituency? Or is it the constituency representative on their behalf delegating? Is it the province, as the professor is saying? We don't know, right? We just don't know. And if you look through the bill, it doesn't give you these indications, not just of do you designate a judge or not? Is it ZEC or not? But all these finer details, we are left guessing, which is why I was asking that question, even that the time period is retroactive to 2023 and doesn't begin in 2028. Where do we get all that? The bill doesn't tell you, which is why for me, that's the threshold, really, that we are all left guessing and gapping that what is happening. And the whole purpose of law is to have clarity so people can plan.
Okay, thank you. I suppose you did mention a lot about sort of taking it back to the people, and I suppose that's your main point. I'll go on to question 2. So you have consistently emphasized constitutionalism as a restraint on power, but constitutions must also evolve. How do you distinguish between legitimate constitutional reform and what you would consider constitutional overreach without effectively arguing for constitutional rigidity? I suppose that camel, I suppose that, that you mentioned the analogy of the camel a little bit there. Yeah. Where does the camel stop, I suppose?
Right. For me, it's when the rules are being respected, right? When the rules are being respected. Now, and I want to say about that, this question of when does it become, what is too rigid versus what is not rigid. We know what is too rigid. The 1980, the Lancaster House Constitution required unanimity, right? That is how it entrenched provisions. Everybody must agree. Every individual MP had a veto on the Declaration of Rights for 10 years and on the white minority seats for 7 years. That's too much. Sometimes you can say, saying immutability, that you cannot change it at all. That's too much. But if there are rules to change it and we become creative in how we avoid those rules, such as these notwithstanding clauses, that we don't have to respect the rules in this case because we're saying we just have the power to do so, then that crosses a threshold. And I do want to add to this discussion that I think I was happy in the beginning when the professor was saying, hey, look at the Parliamentary Legal Committee. This is not just about lawyers, it's about everybody. And I agree, constituent power is everyone. But I do get concerned when we start narrowing it down to, is it in the law? If it's not, then be quiet. This conception of if there's no requirement for a referendum, that's the end of the story. Because when Robert Mugabe put the constitution to the referendum in 2000, which is when some of us first started to know Professor Moyo, there was no legal requirement to do that. This was just Robert Mugabe's own conception of the fact that the people need to have a say here, right? There was no legal requirement for that. And we know in life there are many norms for which we don't necessarily need to question the legal requirement. If that was the case, people would have stopped paying bride price in the 80s. Why do people pay bride price? Which law requires it? Absolutely none. But there are other norms, right? When we're talking about a polity, it's not just about lawyers, and it's not just about law either, is what I'm adding here. That this is why I gave people that reference to that case from Uganda. It has constitutional provisions like ours. And the Ugandan Constitutional Court said there is no constitutional requirement for this referendum. But we are saying this is the term that the people gave you, exercising your power. And you've changed that term. The people need to have a say. Like, it's clear. And like I said, power for elective office in Zimbabwe derives from the people. Where is that power going to derive from 2028 until 2030? Presuming the professor is correct that that's the timeline. Currently, we know where that power derives from the people. There was an election. People gave you from 2028 until 2030, where is that power going to derive from, right? And this is why when people say, hey, how about in 1987, we changed the presidency? How about in 2007? Those were all within, to use a word we're using a lot today, the election cycle, right? None of it was to avoid an election. All of it was towards the election, where the people would actually have a say. Are we happy with what you've done with the executive presidency, or in 2008 by shortening the term from 6 to 5 years? If not, But in this case, it is to go away from the people, both in the form of a referendum and more broadly in the conception of choosing who is the chief executive of the country. For me, that is when it goes too far. This creativity, this reduction to legal positivism, which you would expect to be coming from the lawyers. If it's not in the law, you don't have to, but we know there are other norms, right? And this is why the Ugandan Constitutional Court is coming saying, hey, there are these other considerations of who is the VNA, who are the people, and how can we justify Parliament and the president staying in power without any popular mandate? That's why, like I said before, the president can appoint judges with a popular mandate, right? With a popular mandate, you can appoint all these unelected offices, but now the president is also indirectly elected. That, for me, is when it goes too far.
Tinashe, with your permission, can I do a quick pushback to the good doctor?
Absolutely, go ahead.
Doctor, you made a solid argument that I've understood. Doc, but clearly every country has its nuances. Every country has to face its own contextual realities. And yes, in as much as those laws are there, but if there are ways in which the outcome regarding amending the law in this particular context, which you don't agree with, but really the broader argument being creating stability in a place in which it has been agitated by a consistent cycle of non-appreciation of the democratic process by virtue of opposition leaders left, right, and center, be it from Morgan Changaraya all the way up to Nelson Chamisa, arguing that, well, listen, this process is not legitimate. Equally pushing the country backwards in terms of capital markets, in terms of its capacity to draw in investment, but dealing with equally crippling sanctions at the same time, if one is to make this argument. Is it therefore not important to be creative about that very law in order to then look at the broader picture of stability? How would you answer that?
So I broadly agree with what you're saying, and my response is going to be that there is something that I want to call a Mugabe ethic, and the professor is well within his rights to then correct me in his final if I'm wrong about this. But I want to call something a Mugabe ethic, which is the fact that there was a certain insistence on processualism when it came to Robert Mugabe, such as the fact that when Joyce Mujuru was about to be dismissed from the party, and I remember he was at the party headquarters, and the supporters and the president was like, even did Masumtasa, we have him here, and there was uproar. We don't want them anymore. They must go now. And I remember President Mugabe's response was actually, and I think he said it in Shona, right? He said, like this was President Mugabe holding his own supporters at bay. That's what I'm saying about processualism, that we are going to Congress, right? The process matters, right? And there was always this, it seemed that there would be a process in which the nation is somehow signaled about the changes that are coming. And it seemed, whether you believe it or not, to be grassroots, to be ground up. And what has happened in Zimbabwe is what has been ground up was this insistence that we want the president in power until 2030. What we're told in the debate is not the point of the bill, but this is what we're prepared for all along, right? And it's interesting if you look at the phrases the president himself used. I'm still looking, I can be corrected. I've not found a phrase where the president says in 2030 is when I'm leaving or I shall leave. The phrase was Ndendi Chipo, I will still be there. I didn't actually get a sense from the president.
So just a slight pushback on that.
Yes,
but yes. The president is also public, maybe numerous times saying, listen, I'm a constitutionalist. When the time comes, I intend to leave. He did it prior to his election, the last election that he did in his the traditional electoral interviews that you do prior to the day of the election. He did it equally at a conference, at the ZANU-PF, I think all three ZANU-PF conferences. And he equally did it furthermore when he had just got in. So are we not then therefore seeing this not as a national building process and rather looking at the assumptions we have of whether or not the president intends to extend his stay?
Well, the first issue is there was an expectation to deal with that issue of staying, and then suddenly we were told we are changing how we appoint judges and chiefs can now engage in politics. And So what the public, I feel like, was prepared for then became radically different from what was presented. And as you are saying, the president has continued to insist that he's a constitutionalist, right? So what does that mean? I feel like I'm in the debate again about term versus time, the one that the professor was referring to. He has said he's a constitutionalist, and when his term is up, he goes, right? He has not said, so within the term, which is why I'm saying the Constitutional Court says it's about length of time. And the president has not said when the length of time in the current constitution is up for me to be in office, I'm going. He said, I'll follow the constitution. So whatever the constitution shall say shall be followed, right? If the constitution
so by that very argument, then I could go back to the argument you were making earlier about process. Perhaps, if indeed your assumption is correct, there's a procedural element to this by virtue of the tabling of a bill. And if it is argued in Parliament and it passes, then it goes to the Constitutional Court and they win the argument. Would you therefore concede that perhaps you were wrong?
If the Constitutional Court rules that way, to that extent, I have to concede I'm wrong, but I have to read the judgment to see whether the judgment confirms that I was wrong in my reasoning. I would, yes, at that point, if the Constitutional Court says so, I have to concede. Certainly, my reading of the current Constitution is that if any term-limited office, and I'm including the presidency, is getting more time, they have to go to the people. In this case, I'm getting a sense that not only were people unprepared for these changes, but there's a deliberate move to avoid getting the people to speak on these changes, and even later on to decide who is the chief executive of the nation. But in that case, I would have to concede I was wrong, and probably the professor is right, depending on what the court says.
Right. Thank you, Dr. Hofisi. Now, we'll quickly go to our Q&A. Now, and firstly, allow me to apologize. We had initially planned to cap this at 2 hours. We've gone radically over that timeline. So we're going to quickly take a Q&A from you, the audience. Michelle has been curating the people in terms of the questions. Michelle, if we can take questions within the framework of 2 hours, sorry, not 2 hours, sorry, within the confines of 10 minutes. And if there are people you'd like to bring up as well, please feel free to do so, Michelle, so that they can interact with their panelists directly. Michelle, over to you. What are you thinking? What are the questions we have, and who are they targeted to, or are they open-ended?
Hi, currently we only have one question. The question comes from Justice Mahoney from Twitter. The question is to Professor Moyo. The simple question is, if there is no upper limit or finite term for the president, in this case 5 years, why is there need for CAB 3 to extend a term limit if it's not necessary, just like the referendum he asserts is unnecessary? In this case, why Labour to extend it in an amendment? That's to
Michelle,
you,
you may need to read that again. Professor Jonathan, are you there?
Question, break it down for me. I don't understand what the question is.
Yeah, no, do I, to be fair.
Okay.
Can you read it again, Michelle? And do it slow.
If you can take a look at your screen as well.
No, just okay. The screen, okay, the screen there. Okay, just read it. Read it for us.
The question to Professor Moyo is: if there is no upper limit or finite term for the president, in this case 5 years, why is the need for CAB 3 to extend a term to extend a term limit if it's not necessary, just like the referendum he assessed is unnecessary? In this case, why Labour to extend it to an amendment? Sorry.
Okay, so let me read this. So the simple question to Prof. Moyo is, if there is no upper limit or finite term for the president, in the case 5 years, why is the need for CAB 3 to extend a term limit if it's not necessary, just like the referendum he asserts is unnecessary? In this case, why Labour to extend it in an amendment? Yeah, no chirungwa, but chirungwa, no, but yeah.
If I'm understanding, first of all,
I think yeah. Now I get it.
Can I swiftly say something? I'm going to just say what is my understanding of the question, and I could be wrong.
I hope you are.
Yeah. It seems to me the question is, why is this change happening in section 95, Professor, if everything is actually happening in 91, as you say?
Yeah, I didn't say that everything is happening in 91.
I just mean the bill. Like, why?
Yeah, no, I understand now. I hope you will give me some leeway to answer the question now that you have clarified it. And the answer is that I did not say, and I do not believe that everything is happening in 91. In fact, we are clear, all of us who can read, that there is no touching 91 in the bill. It remains untouched. What does that mean? It means the term limit provision remains intact as it is, as it was enacted in 2013 and slightly amended in 2021 without changing the length of time. It's very important, colleagues, at least for the sake of understanding each other and what the arguments are, to appreciate the point that the bill does not take section 95 subsection 2 as a term limit provision. It recognizes and respects section 91 to subsection 2 as a term limit provision. And it is that section, in terms of the question, which says, for purposes of the two-term limit mechanism, 3 or more years are deemed a full term. The question, as I understand it, it then asks, if there's no term limit extension, why is the bill bothering to extend the 5-year period, term, cycle, term length, call it what you want? Well, this is linked to what section 91 subsection 2 says. When it says 3 or more years, it doesn't mean the more years are open. The more years depend on what the Constitution says is the electoral cycle or the term length. But what is clear is that if the intention was to say 5 years, there would have been no hesitation in section 91, subsection 2, to say minimum 3 years, where the maximum is 5 years or whatever. There would have been no need for that construction at all. The reason there is that construction, in my respectful opinion, is that it is tied to the electoral cycle, which is not a term limit, because it is not limiting the office holder, but it is limiting the existence of this cycle, which can be occupied by different people without redefining the maximum time they can spend in that office. So if we go by what the Constitution provides now, we don't need a rocket scientist to tell us that the more is 5 years. That is so clear, because that is the electoral cycle. But that provision which deals with the electoral cycle is not a term limit provision, and it cannot be reasonably called a term limit provision. And in any event, it will be absurd to have two term limit provisions. That provision clearly is structurally linked to the duration of Parliament, and it is linked to the timing of elections. It's one thing to have a provision telling you how long the road is and what is the road, and another to tell you the qualifications of the driver on that road. The Section 95 defines the road and its length, 500 kilometers if you want. And if you drive only 300 kilometers, you have a journey. And if you are limited to 2 journeys, either your journey ends between 3 years and between 300 kilometers and 500 kilometers, or it ends at 500 kilometers, but you can only drive twice. And in order to drive twice, you have these limits on you. You can't drive without a license, you can't blah, 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 blah. And the regulation of the driver can't be the regulation of the road. The road exists with or without the driver, and several people can drive within the same journey. That's one thing. And that, I hope, should make the colleague understand this idea to say when you define a single length without putting the maximum that is imposed on whoever is the office holder and so forth, you are doing just that. You are defining a single length. That's what you find in the Constitution of South Africa. That's what you find in the Constitution of Botswana. That's what you find in the United States Constitution. They did not change the length of the time a president can serve, which is 4 years, just because they adopted the 22nd Amendment. Where there is no trickery here. If you follow what I suggested, with all due respect, to be the mischief at play, I said one mischief is the method of electing the president. That's a serious mischief to address. The second mischief is the short term length, that periods that we have had, namely of 5 years, related but different. That's why we're changing, and the change is only on the length and not on the term limits. There's no touching the provision that regulates the term limits, is my answer to the colleague who has asked the question.
Thank you very much, Professor. I believe there is a question that is to no one in particular over here. This question comes from Citizen Zethi. The question is, can an extension 2 years be done after the amendment passes, moving 7 years to 9 years and 9 years to 11 years and so forth? Again, the question will appear on the screen for you to read for yourself.
I would like to rephrase the question for Dr. Hofisi. Do you understand the question, which I think you should answer, Dr. Hofisi?
Yeah,
is it rational? Let me rephrase it for you to help you answer it. Is it rational to say, by making this amendment, especially with respect to clauses 4 and 9, does it mean, therefore, it makes rational sense in constitution making that every government or president who comes will be tempted to increase by 2 years, by 2 years, by 2 years? Is this amendment, from what you understand about constitution making, inviting floodgates of the nature alleged by the questionnaire?
All right, I think you know. I think you know my answer. My answer is obviously yes. For those who are following U.S. politics, you remember. For those who are following, right, that the state I'm in, Virginia, just passed last night a redistricting plan, which is going to give Democrats 10 more seats. And the fear about a state legislature-based redistricting was always the nature that is in this question. That if Republican state legislatures start redistricting in order to ensure that at the midterms Republicans win more seats, the danger is that all Democrat-controlled legislatures will do the same. And that is what is happening, right? And so my answer is, like I said before, right? The camel and the tent, right? Or the blind man and the elephant, right? There's an elephant and we're just holding the tusk or the tail. So my view is that this sets the stage for that, in the same way that removing interviews for the Chief Justice and removing interviews for promotions within the judiciary set the stage for removing interviews for all judges. In the same way that removing interviews for the Prosecutor General set the stage for removing the Judicial Service Commission for the Prosecutor General all the way. And in the same way that removing the public protector.
Please don't please. If you can cut it short, please.
Okay, I think
We'll
that's
go to the next question. So I think, Michelle, we can take a final question and then we go to closing remarks. We've already eaten into our time by an additional hour, and we are known to be time people. So we're not doing well in that regard.
I have got a question here. Unfortunately, it's come through a different channel and it cannot be shown on screen. It is from Chabata. In the 2018 and 2023 elections, many constituencies exhibited split-ticket voting behavior, where voters differentiated between presidential and parliamentary candidates, even within the same political party, reflecting a strong candidate-centered voting pattern. How does this bill help the situation? I might like the parliamentary candidate, but not like a presidential candidate, for instance. This has not been, again, given to anyone in particular. So it is open for discussion between.
Let me just say in a second that if the question is how does this bill relate to the split voting that happens in any election where there are several elections, as it were, parliamentary, for example, presidential and local government elections, and you get 3 ballot papers. But also where if the ballot or the voters are voting, but splitting the vote for the president going one way, for the MP going the other way. Does this bill deal with it? Yes, it deals with it by getting rid of that kind of election. It won't happen again if the bill passes. But the fact that it happened that way in 2018, and also we know from the 2023 results that it happened, is not of a concerning moment, and is not what the bill is addressing. But that is typical of voter behavior, where they are.
Professor, would you allow me to push back on that?
Of course, it's your show.
Well, no, it's our show. Prof, let's pretend you are right. What if the voter base then revolts because they were not consulted? And as a result,
no, but I'm right about what?
If I may, then
right about what?
That no. So what is the context of the question? The question is that voting base would prefer a parliamentarian in their constituency that they communicate with, that they know, as was the case with you many years in Cholocho. I believe you. I could be wrong. I think you're the first ZANU-PF elected constituent from Cholocho. I could be wrong, if my history is correct. But the point being, if this system of a sort of divided votes in which people vote according to their local interests rather than the national interest, purely out of preference, and then go for the opposing party. Hypothetically, let's say Nelson Chamisa, who has a CCC, well, I don't know what's happening there, but let's pretend the MDC was functional and they still had the metropolis. Now, if their vote was purely based on the fact that it is Changirai, then it changes all of a sudden to now it's about the councillors or the MPs whatsoever. Is there no risk, therefore, for their voting base to shrink because they have a different preference of the leadership?
No, but the question, I'm sure will agree that and he had the ZANU-PF vote in mind. He would agree that actually the total vote that went through ZANU-PF, even where they were voting for their MP but not voting for the president, did not shrink. Actually, the ZANU-PF vote increased. It simply means.
You're not answering my question.
I don't understand your question. I mean, why don't you ask a question and not give a
when we had Zuma in South Africa, KwaZulu-Natal vote was guaranteed, and therefore the margins were guaranteed. When Zuma left the ANC and he had differences with the ANC, it ate into the margins of the ANC, and as a result, by the way, this is the model you used as an example of what we're trying to go towards. When they had Cyril Ramaphosa, that vote margin shrank.
Yes.
So my question is, you are correct to say, because if we reread the question, he's asking, how do you deal with it then when you're now changing it from a person being able to vote for their constituent, a person they know they've grown up with, but they may not know who the head of that party is. The trust may not extend beyond the local. And you always used to say, by political science, politics is local.
How does that relate to the fact that it's the member of parliament who is going to be voting with other members of parliament for the?
Yeah, but the point is that perhaps the feelings of the leadership, whoever that may be, are stronger than whoever it is that is, and they would deem it as a betrayal.
Well, I don't know if the question really meant what you are.
No, I want us to think broadly. The questioner may have his own intent, and maybe he may be a member of the I don't know. But I'm thinking as someone who's thinking outside of that confine.
Yeah, because the example you give shows precisely the point that because of whatever decisions the ANC took in respect to Zuma, they lost the vote from where Zuma comes, and MPs were elected from there when they were in parliament and voting for the president, which is when they voted for president, when Ramaphosa was the candidate. They didn't vote for Ramaphosa, and there were reasons. And I don't understand what the problem is with that. I don't understand the structural problem, because that's exactly what you would expect to happen, where the local people.
Oh, I see your point. Okay, I see your point. Michelle, any further questions? Sorry, maybe obviously it was directed to both. So.
Well, it depends. If there are more questions, I'm more willing to entertain them than to engage.
Michelle, are there any more questions? If not, let's go to closing arguments.
There are a couple of questions.
Can we take one more and then we close? Thank you.
Yeah, we can take one more. I can find one more. This one is again for the professor. People seem to like you, professor, to ask you questions. This question is from Taxi Driver on Twitter. It says, can you please ask the professor if he believes in a one-party state? If yes, why? And if not, why not?
I fortunately happen to know a Taxi Driver. He runs one of the most interesting Twitter spaces on a daily basis, but certainly regular basis. He knows only too well that I was one of the most vocal people from the University of Zimbabwe against the introduction of a legislated one-party state. I don't believe in a one-party state. I have never believed in a one-party state, for the simple reason that you can't regiment people into a legislated framework which forces them in terms of their political affiliation and their choices. It's very important that people associate and affiliate with like-minded human beings in pursuit of their common good within the framework and parameters of a country. And there's no reason to suggest that anything in the bill is for a one-party state. In fact, it is dismantling the bill. One major institution that was created by that thrust in the late 80s and early 90s towards a one-party state. Earlier, Dr. Hofisi referred to the fact that two of the key legal minds who worked on that project were the late Dr. Edson Zobu and the current president. And for me, it is quite salutary that the president, who was part of the team that led that project, understands it probably better than most, and who is a sitting president, is presiding over a major reform of something that, honestly speaking, I know that even those who are currently saying, oh, no, we don't want to take away this and so forth, for the better part of their political life, they were the most vocal critics against the creation of the executive presidency. Many of them defined or described it as an imperial dictatorship, and they didn't support it. When they were given opportunities to for constitution amendment in 2000, they rejected the executive presidency. They even came up with their own NCA document, constitution, which doesn't have the executive presidency. It eliminates completely, and it has a prime minister. And they came up with a Kariba draft, which never saw the light of day. Again, they had problems with the executive presidency. Come 2013, it survived because the two major principals wanted it and agreed between the two of them that this is good, they must not touch. But there was an attempt to touch it, a serious one. And they wanted to get rid of it precisely for the reasons that are in the bill. However, out of political convenience, they ended up keeping it. Ask Advocate Monzora or anyone else who was involved. Some of us were deeply involved in that process, and we know exactly what was happening. We know what the initial drafts contained. I can tell you, it's only now, in respect to this bill, because there are some people, when it comes to constitution making, they take a tactical position that we must say no. We will say yes to the same thing when we are in power. If we say yes now, we will benefit the wrong people. There are others, like me, whether you're looking at 2000 or you're looking at 2013, we don't take a position depending on how do we get rid of the bad people, how do we push the good guys. We don't even subscribe to this notion of good guys versus bad guys. It's never been a constitutional principle. In fact, in political science, it doesn't work, that kind of a method. But I want to tell you that there is no new argument being advanced today for reforming the executive presidency, which has not been with our body politic. And that the majority of people who are jumping up and down opposing it are, in fact, the people who wanted it for the better part of the last 20 years. Thank you.
Yeah, Prof. Thank you, Prof. So, listen, just for the interest of time, Michelle, what I'm going to do is there is one question that I think, in the spirit of fairness, we can target to Dr. Hofisi. So, Dr. Hofisi, there's a question here that says, to what extent does Constitutional Amendment Bill number 3 risk facilitating executive aggrandizement through the weakening of judicial independence?
All right, thank you. Let me answer that in full, but I also want to still mean what the professor is saying.
Dr. Hofisi, are you there?
You can't hear me? Something's happened, huh? Hello?
Michelle, just check if he's not muted.
Something's happened.
No, he's coming through clearly.
I can hear him.
Okay.
I think.
We can hear you, Dr. Hofisi. Go ahead.
Dr. Hofisi, I think you're muted. Sorry.
So what happened? The goblins have migrated.
I'm the only one who can't hear you.
Right. Looks like.
Michelle, Nyasha, can you hear the?
I can, yeah.
Shit.
All right.
Dr. Hofisi, you can go ahead. We can all hear you.
All right.
Sorry. Thank you for trying. I think I can also hear you now.
Okay. All right. All right, let me fly through. How does it allow executive aggrandizement by undermining the judiciary? And I think this is part of the reason that explains some of what the professor is saying. I want to agree with some of what he's saying and to actually extend it to say, indeed, even the Law Society draft constitution also did not have a directly elected president. So that part is certainly true. And I hasten to suggest that if the current bill was doing what was in the NCA draft, in the Law Society draft, then and if there was a process of making people appreciate why we're dealing with the executive presidency that way, or even in Lancaster, right? Because Law Society and they were going back closer to Lancaster House, that arrangement of a president who appoints, but a president who also has some internal check over the prime minister, I think is what those were going for. But in this case, part of what becomes frightening is indeed the circumstance. So what you're also saying, Professor, I want to also agree with that there is something that we must acknowledge when, for instance, the military can no longer uphold the constitution at the same time that the president's tenure is being extended. I think it's very different if the president was going and, okay, as the president is going, let's also deal with the military. As the president is going, let's change the system of, I think things do change. I think that context matters. That if the president is staying, but all these other offices are the ones that are being checked, it colors. And then the specific question, judicial independence. Yes, let me try to be brief. Not only is the president appointing all the judges now without public accountability. So there was a moment when we could actually see what the Judicial Service Commission is doing. And we see the performance versus who is appointed. That is public accountability. It is gone. And then the court itself is getting a new power to deal with matters of public importance. And if you look where that power is being given in South Africa, that has resulted in docket drift, because remember, constitutional cases don't come up a lot. So they'll deal with more cases that are coming up with the Supreme Court. There'll be less focus on defending the constitution and more on these general law matters and getting into specialist areas from lower courts. And let's remember, the president himself is only being elected by parliament, and then is getting to elect, and like I said, appoint from the lowest levels all the way up. So those are serious implications for the judiciary, which we're not giving this extra power only when we've removed the capacity for this public transparency, public accountability.
Thank you, Dr. Hofisi. And I'm cognizant what time it is in Kenya and the United States. At the same time, I'm equally cognizant that I have a family as well, and Nyasha is a mother, and Michelle has a home. I think with that being said, shall we allow our panelists to give their final remarks? Please do spend 1 minute each to give your final remarks, your parting shots as closing remarks of the argument, and we will equally do the same. But before you do so, I just wanted to thank our partners at Press Reader, and equally our partners at the Ministry of Information and Broadcasting Services in Zimbabwe, who have supported this. We have a content sharing deal with these particular partners, and we hope that tomorrow's Herald will equally share the argument in its full context, rather otherwise. With that being said, I'll start with Dr. Hofisi for your closing remarks.
All right. Jesus. Okay. I want to say development, whatever development people are happy with, comes from being stress tested from elections, and we shouldn't fall into the trap of extending the deadline. When a student is doing well, we don't remove exams. That stress testing is giving good performance, and we need to continue to have that stress testing. And let's also all remember that our views do actually matter, right? And what they are, it is an outcome that is being manufactured. It's not fait accompli. So let's continue to engage and make our feelings heard on this issue. And remember that everywhere where you've got development is some measure, some form of an election of stress testing. I want to thank you for hosting us, Farai and your team, all the sponsors. I want to thank the professor for agreeing and staying up so late and keeping it civil. And I am reserving my last 15 seconds to also say that it's my first engagement with the professor. I hope it's not the last, but if it is the last, I also want to specifically thank him for all the positive feedback I always hear about how he treated people he worked with in the ministries that he was. So not just the policy, but the way we treat human beings, I think, is very important. And for that, I want to thank you, if anything, on their behalf.
Absolutely. I think that, and I must compliment and commend that, because there's a story to be told about, you would know, Hofisi, about the time when Professor was Minister of Information, and I was still in Zimbabwe at the time. I think we're talking about 2002, 2003, and we were local musicians trying to find an avenue, and we couldn't get into radio stations. They wouldn't simply take our music. We had to send, especially from Moyo, you had to send your music to Grammar Records, and Grammar decides, and then, you know, when Professor introduced the 100% local, it really launched a lot of us. We were able to build a small economy for ourselves. So yeah, there's a lot to say about that, and I thank you for crediting him for his work and experience. Over to you, Professor, your closing remarks.
Thank you very much. With 1 minute, let me quickly run through 4 points I wish to emphasize. One is that I appreciate the point or argument by colleagues that it's important to go for a referendum, but I just want to remind them that in 2000, there was no requirement for a referendum because it was not in the Constitution. It was the Constitutional Commission that caused it and caused also the enactment of the Referendum Act, under which that referendum was organized. And it was the same act used in 2013 because the Constitution did not provide for a referendum, but it was a political agreement. The major difference now is that unlike then, we have a Constitution which provides for a referendum on constitutional matters and how and when they can be held. I believe this might sound unfair, but it is simply unconstitutional for people to demand a referendum where the Constitution does not require it. Secondly, I feel this is important. Dr. Hofisi raised this issue about counting from 2023 to 2030. This is in clause 4 in respect to the president, where it says delete the words 5 years and substitute with 7 years. And then there's the non-obstante clause, which says notwithstanding section 328, subsection 7, subsection 2b, which extends from 5 to 7 years, shall apply to the continuation in the office of the president. You continue from the beginning. This reforms the length right from where it started. You can raise the questions of retroactive application, which people haven't raised, but which are adequately addressed and which I will not go to now with this summation. Is the same with amendment of section 143. It says regarding the duration of parliament, delete the words 5 years and substitute 7-year term. And then it is the non-obstante clause, notwithstanding section 328, subsection 7, subsection 1, which deletes the period and lengthens it, shall apply to the continuation in office of the Senate and National Assembly. This means the presidency, the Senate, and the National Assembly elected at the last election continue to the end of the 7-year period, which is 2030, when you will have the next election. That's not a cancellation of any election. That's simply an adjustment of the election cycle. Now, I want to finally say, as far as I'm concerned, how a country elects its head of government is so critical because it determines its national politics. And there is no doubt to my mind that the way we have elected the president or elected the president in terms of the current law is inherently divisive. As I said, it makes it possible for 4 provinces to elect the president, regardless of how the other 6 are voting, even when they are not voting. That is a theoretical possibility, And the simple fact that it is possible to have such a scenario means the method we are using leaves a lot to be desired from the point of view of national cohesion, national unity. Lastly, the question that we simply adopted at independence, which we did not interrogate in the same way, especially now, we are interrogating the adoption of the indirect election of the executive from 1980 to 1987, and you're saying it was just imposed on us by the colonial masters. They also imposed 5 years. And they imposed it from a textbook point of view as an adequate period. But we know, especially what we saw from 2018 to 2023, that the period is vulnerable to all sorts of things. The reason why the 2030 agenda policy, which on paper is one of the best you'll get, it was adopted in October 2018, but it was unimplemented until in 2020, a new instrument for implementing it was adopted, which is the National Development Strategy 1. But it too was not implemented because of toxic policy for one, events of January 2019, events of July 2020, but also by COVID-19. And the governance trust was lost. And that is why, whether we agree with them or not, the ZANU-PF structures came up with that resolution. But the interpretation of that resolution has been very positive, and I think has given us to address structural problems that a short election cycle of 5 years is inadequate. And most African countries, notably Guinea in September last year, have revisited this period. It's a period imposed and a period open to review. And I'm glad that Zimbabwe, as the leadership and government, that has decided to take the bull by its horns and tackle this matter, which is not only Zimbabwean, but African. Thank you.
Thank you, Professor. With that being said, I want to...
Oh, sorry. No, sorry. You were intimidating me, and I then forgot to use this
Professor,
last opportunity to thank you. I want to take this opportunity to thank you and the other organizers, the Minister of Information and Press Reader, and to thank you individually for the professional manner you moderated the session. And it's a pleasure to engage Dr. Hofisi. I follow his writings, and I think it's instructive that he engages and disagrees in a manner that challenges the mind and not the heart. And one doesn't get angry to want to fight, wants to listen and follow the argument. So it's been a pleasure to be part of this type of engagement. I too hope there will be other opportunities.
Absolutely. If other people don't think of it like as we generated it, I'm sure we will do it again.
So thank you very much.
You're most welcome. And I just want to say, and maybe as a preamble to my closure or my conclusion, I just want to say Zimbabwe as a community, we currently have over 1,000 people subscribed watching us right now. And I want to say that we have an opportunity either to build or destroy. And sometimes these things start with conversation. And it's up to thought leaders, as we have here on the panel, to demonstrate that particular leadership. And I think in our individual capacities and our areas of influence, we can do the same. I don't think it should take a constitutional amendment or whatever it may take. I think we can start having conversations, even with regards to this very amendment, that if it is to do us better, let's have a discussion. And I think it's important to always conversate. And part of the reasons why we built the Southern African Times was the misrepresentation of Africa's narrative. that we are, we are violent, that we do not listen, that we cannot be controlled. A colonial terms have always been our tagline, and we seek insights elsewhere. I hope that this becomes the foundation of something new in which we engage, we discuss through debate and substance. And I think what we endeavored to do here, I think I hope was accomplished. I can't speak for you, the listeners, for you who's at your home, or you, the mother who is watching, wherever you're watching. But I want to appreciate you for making time, and I do yet again apologize for the late start, but we got there in the end. Thank you also to our panelists, mainly both Professor Jonathan Moyo and Dr. Hofisi, who spared time to come and spar, and they made great sparring partners, because I learned a lot. My notebook is filled with a lot of takeaways that one could learn from. And then more fundamentally, given the importance of this discussion and the conjunctural moment we are at as a country, it is important that we engage civically by learning, engage, debating, and continuously building upon that. And I also want to thank my
It seems we have lost Farai. Apologies, and bear with us a
Yeah,
moment whilst he tries to reconnect.
that's poetic justice.
In the meantime, Nyasha, would you like to say some words as well in closing?
Yes, I'd just like to say thank you to Professor Jonathan Moyo and Dr. Hofisi. Just the opportunity to obviously be on this platform, and again, thank you for being so gracious and so intellectual in your arguments. I think the importance of having such a platform is just about telling.
I profusely apologize for this.
I'll just complete what I was just saying. I was just saying that we're grateful, obviously, for the platform, just as those of us in the diaspora being able to tell our own stories and not have a narrative that is projected by a completely different lens. Just
Thank you
wanted to
so much.
say thank you. Yeah.
Thank you so much, Nyasha, for that. And for that, I want to thank you, Nyasha Matanda, who is one of our editors. She runs her own independent editorial in cosmetics, but with a background in law, and I thought her befitting to be our partner and moderator. And equally thank Michelle Mungeni, who is in the background, making sure that everyone is happy, making sure that answers our engineering process are done. And equally thank the rest of my team, our managing editor, Leo. I can never pronounce Leo's last name, so forgive me. But with that being said, thank you all for tuning in, and I thank you yet again, Professor and Offici, and I hope to do this again. This is quite good. It's very good and engaging. And lastly, I'll thank our partners, Press Reader and the Ministry of Information and Broadcasting Services of Zimbabwe. With that being said, ladies and gentlemen, we have come to the end of our session. Please stay blessed. And you don't need to stay here, but you need to get the hell out. Take care. Michelle, we conclude.